My lord, in item 1, on the last occasion also, the petitioner's counsel did not appear. And we had submitted the status report also, whereby the execution of that state data center has been completed. Now, nothing remains in this petition. Yeah.
It's to be done.
This can be closed since the petitioner's counsel also is not appearing. They have also
It's a PL, no?
appeared.
It's a PL.
Yeah.
Just can close like that.
We have filed our affidavit of.
What is your stand?
Our
Was
stand was
it
that,
properly through NIT?
yes, their contention is that without plotting any NIT, we
Yes.
had awarded the work. Our stand is that we had plotted NITs 6 times, madam. Earlier, there was no one coming up. Ultimately, we have, on the last occasion, we have asked the PSUs, public sector undertakings, to give their quotations, madam. Then thereafter we have selected.
There is nothing. This has been listed for orders. We'll list it after 3 weeks, or 4 weeks, huh? We'll see on that day, because it's a public interest litigation.
Yes, yes.
And we'll see on that day, we may think about, imposing a cost also.
Yes.
Non-APS for the petitioner on call. Next para, Mr. N. Rathod, London, Additional Advocate General of the State, APS for the respondents. List after. Your that status report has been recorded.
Yes, my lord, on the last
Taken
occasion.
on record, it's okay.
Yes, yes,
List after 4 weeks.
always.
May I please, Lordship?
Yes.
Lordship, the respondent authority yet to file affidavit. And
Huh?
yet to file affidavit by the respondents.
It's okay, but what is there?
So this matter is the illegal awarding of tender work act.
Who you are? Who are you?
My lord, I am General Secretary and IT in charge of Arunachal Contractor Associations of Likawali, West Siang, Lord Siang districts.
Are you a proxy?
No, my lord.
Then why you have said that it deprives all other eligible the contractors?
My lord, since we are working
It's
for the
nothing.
interests of the contractor, all the eligible contractors, and
Who
in
is
fact,
respondent number 6?
6 we have taken steps, my lord.
Huh?
We have taken steps on respondent number 6, the private respondent.
Otherwise, it's nothing. There's nothing. Anyway, heard Mr.
And Rama.
N. Rama,
Yes.
Learned Counsel for the petitioner. Award Service Report. MSP Pangu, Learned State Council may file affidavit. Affidavit no opposition.
My lord.
Next date, you come prepare. There's nothing. Rather,
My lord, in
it
fact,
appears to be you are the proxy thing.
my lord, but actually, this petitioner, they are not a contractor.
Huh?
They are not a contractor, in fact.
You are filing on behalf of the contractors.
Yes. But
Yes.
no, my lord.
Then we'll hear you and we'll dismiss.
No, my lord. On
Is it permissible? You are not a contractor, but you are on behalf of the contractors, rival contractors.
inter-register, my lord, inter-register contractor within the district, my lord.
What does it matter?
Because We are not representing only single and contractors. We are representing on behalf of entire registered contractor of the concerned
How
district.
can you do that? How can you do that?
Since well, our organization.
Are you a contractor?
No, I am not a contractor.
Huh? Are you a contractor?
No, my lord, I
Then
am
you
not
are representing the contractors
entire registered contractor, my lord, from the concerned districts.
on that ground only. Will dismiss it. Are you sure?
My lord, let affidavit may be filed.
Doesn't matter. It's a public interest litigation. If that is your submission, we'll hear you and dismiss it.
My lord, let them come with affidavit, my lord.
Hmm?
My lord, the government respondent may file affidavit, my lord.
It's a public interest litigation. You are filing the public interest litigation on behalf of the agreed contractors.
Yes, my lord.
Yes. How the PL will lie?
My lord, since contract workers if awarded to the genuinely registered contractor.
Okay,
within
we passed the
Arunachal
order,
Pradesh.
but then you take that, you read the judgment. Balwant Singh Chopwal, 2010, 3 SCC 402. Have you read that?
So, not my lord.
2010, you write down.
Yes.
Read and come back.
Yes, sir.
2010, 3 SCC 402.
Yes, ma'am.
It's not only for this. Since you are a lawyer filing a public interest litigation, first you read that and come back.
Yes, ma'am.
Should I record your submission?
My lord, let
Anyway.
affidavit may come.
This after 4 weeks.
Much.
Mr.
M. Khambo.
N. Kambo.
M. Khambo.
Kambo.
Yes. My lord,
Learned counsel for the appellant. And also Mr.
Jitado.
Gita, learned additional PP. Office note dated 10/04/2024 reflects that ID card is yet
My lord,
not
next
yet
date maybe,
received back on behalf of
And-
respondent number 2.
my lord, kindly fix date may be given. Next date.
Hmm?
Fix date may be given.
List
Next
after 4 weeks. List after 4 weeks. Records.
IA,
Record is there.
your own, my lord, one IA is also there. Kindly it may be also listed together.
Records is there. The records have been received. List of registry to prepare the paper book. List after 4 weeks.
Okay.
Okay.
Nice.
Yeah, please, Your Lordship. Lordship, I have gone through the citation suggested by Your Lordship. Yes. I'll leave it to Your Lordship. I'll leave it to Your Lordship. Since when this petitions was filed, Lordship, there were certain grievances, Lordship. So our sole grievances was that since that office, DMO office would be shifted, then along with him, other officers who are working as MO as well as they are holding other posts, say DRCHO, they would be automatically shifted along with.
Now the district hospital is at Hawaii
No, Lordship. It's at Swami Camp, Hyolian, Lordship.
still. District hospital.
Lordship, yes. It's still there. It's not been shifted But the DMO office, they were planning to shift.
You said
Why?
the cabinet has decided accepted your proposal.
That part, Lordship, we couldn't take proper instruction, Lordship.
Lordship, as per our instruction, there is no such decision has still reached to those authorities.
Any written instruction?
Lordship, I will produce that now since is there we printing could not be done, Lordship. Otherwise, we can submit later on.
You don't want to argue?
Lordship, arguments, but Lordship, since I have seen that citations, Lordship generally will be arguing on the policy decision made by the government. Our argument would be on that line only, Lordship.
Yes.
But then there are this judgment suggested by your Lordship. So we cannot argue beyond that also, Lordship.
You can distinguish also.
Lordship, ultimately, the sole argument will fall on the policy decision made by the government. So, Lordship, I'll leave it to your Lordship. Yeah.
No, you cannot just leave it like this. What do you say?
Lordship, there is, in fact, if DMO office is shifted, nothing is going to happen for the district medical. Lordship. That part we have categorically stated in our affidavit.
What? What you have said? Where is that impure order?
Page 25, Lordship, Annex 3.
What about other offices?
Lordship, we are generally agreed by other offices, Lordship.
It's already shifted. No, I
think
just
so.
want to know.
I
It's
think so.
already, all other offices.
Lordship,
have
there
been
is
shifted.
no communication regarding it's presumed it has been shifted.
But the headquarters is Hawaii.
Hawaii, Lordship. We are agreed by serial number 2, Lordship.
Yes, we know that. You are only agreed by the district medical officer,
Lordship.
office of the district medical
Lordship.
officer.
Since along with DMO, other medical officers who are holding other posts, they will be automatically shifted with DMO.
Yes,
That is our sole grievances, Lordship, here. Since they are functioning, they are taking dual charges as medical officers as well as they are taking the charge of other offices, Lordship. Since this DMO office will be shifted, so the hospital will be functioning without medical officers. And our argument, Lordship, that the argument that we have put forward that has been supported by the affidavit filed by respondent number Two, Lordship.
Who is respondent number two? DMO.
Dear. Secretary Health, Lordship.
Hmm.
Secretary Health.
Yes.
They say that there are lack of infrastructure, Lordship.
Obviously, it's a new district, new headquarters.
Hawaii being the headquarter, automatically one or other it has to be shifted.
Lordship, exactly, Lordship. That part we are not disputing, Lordship. But then at this stage, when this petition was filed at that point of time, Lordship, since there was no facilities as such at Hawaii, shifting of the DMOs would not have served any purpose at that point of time, Lordship.
Are you sure this has been filed by the Secretary Family Health and Family Welfare?
Plus,
Is it-
affidavit in opposition filed on behalf of
Is
state
it signed
resident.
by one junior statistical assistant? How can he file such?
Lordship may kindly peruse page 5, paragraph 3.3, Lordship.
No, the affidavit is by one junior statistical assistant. Where's the authority?
Lordship, that part, Lordship, studying counsel will be the better person to, Lordship, address that issue.
How can he file this? He cannot represent the state.
Is Mr. Affidavit is employee of directorate.
Where have you get the paras from?
From DMO.
Yes, that is what we.
Yes, DMO has been met part.
DMO doesn't want to shift. This is basically a petition of DMO. It is, we wonder. He doesn't want to go to the Hawaii. That's why this petition has been in the name of Style SPI. Yes, we're not happy. How the junior statistical assistant can file such an affidavit. That too, he has just meant to sign the affidavit. It is not by the secretary. There is comments from the DMO. He is not the one who will take the policy decision. It is by the state.
I'm appearing on behalf of the
We'll ask the secretary to file affidavit. Heard, Mr. Yes. Yes. In the basis of the periodic has the secretary authorized this man?
Idea because there is no authorization in the report. Because even in the post title, the secretary has not been like party. The AMO is I'm appearing on behalf of respondent number 2 with the AMO.
Who is DMO?
No, Lordship, in my petition, I have categorically made secretary as the party.
No,
Respondent number 2.
DMO is not a party.
He is not party. DMO is not party.
Secretary.
Secretary, Deputy Commissioner, and then Secretary, Health, and Chief Secretary.
Heard Mr. J.G. learned counsel for the petition, and also heard Mr. I learned additional senior government advocate for respondent 1 and 3. And also heard Mr. Arko, learned counsel appearing on behalf of Mr. T. Thagum, learned standing counsel for Health Department, appearing for respondent number 2. During the course of the hearing, it is noticed that the affidavit in opposition stated to have been filed on behalf of respondent number 2, the Secretary, Health and Family Welfare, Government of Arunachal Pradesh. Which has been stated to have been authorized to sign affidavit by an assistant junior statistical assistant of the Director of Health Services and the Department of Health and Family Welfare, Government of Arunachal Pradesh. On the basis of the Pera's comment, Pera's reply prepared by the District Medical Officer, Anjo District at Highway, Mr. On a pointed query, the learned counsel appearing on behalf of standing counsel of the for respondent number 2 submits this. There is no authorization by the Secretary, Health and Family Welfare Department.
Therefore, may I take specific?
No, you find out, do you have the authorization there? We'll say there's no authorization available in the record. We'll just say, right? Is there?
It's not there.
If authority is there, authorization is there, it should be there only.
It's not there. However, it may not be in the record.
In the record, huh? Please look. After going to, on perusal of the affidavit, comma. The stand taken appears to be contrary to the policy decision of the state. Which would not be permitted, as the state has to be represented not below the rank of secretary. System. Come on. Having considered above, the response number 2, namely secretary health and family, health and family welfare department, government department is directed to file affidavit in the matter within 2 weeks. Missed after 2 weeks. Right?
Obliged.
You are saved
Lordship.
today.
Lordship.
You are saved for today on.
Lordship, I'll come up with argument. Obliged.
Petitioner not present. So, in the present appeal, there is no ground. Ground has not been given. And in the line counsel 4, the appellant was directed to file additional affidavit stating the ground. So unless there is a ground for filing this appeal, it will be difficult for us. We cannot just set a ground by ourselves and justify. So has to. Petitioner is not present. Appellant.
No, Lordship, today also not present.
There is a direction. Is directed to file order dated 21/11/2023. Laren amicus curiae is directed to file an additional affidavit mentioning the grounds on which the present appeal has been filed. There is no ground. So let her file.
Lordship.
It will be difficult unless there is a ground for filing appeal. We cannot construct a ground by ourselves.
Lordship.
And,
He was directed earlier to, Lordship, to file the
File the
affidavit.
appeals.
Lordship.
So unless there is a ground for filing appeal, it will be difficult.
Lordship.
On what ground will decide the matter. So let her file. Otherwise, there is nothing.
Lordship. Lordship,
What the petitioner says is correct, but then since the victim is a minor,
Lordship.
so it doesn't have any valid.
Lordship,
Point.
moreover, this Lordship, all the evidences Lordship collected, Lordship,
Prayer is
all the evidence collected during the trial, Lordship, it is against the this accused, Lordship, and the collaboration, Lordship, of the victim as well as this father and the this witnesses, Lordship.
everything, of course, he has also admitted under 164(5) statement also corroborate.
Lordship.
She has, of course, she has also stated that there may be some consent, but then all these things are immaterial.
Lordship.
To give you relief, but if you don't want to take relief, we're helpless. Heard Mr. B type for the learned counsel for the petitioner who submits that he may be granted 3 weeks time to file rejoinder to the affidavit in opposition filed on behalf of the state. Praise the Lord. List this matter after, no, before that. Praise the Lord. Huh? Mr. N. Rattan, learned additional Advocate General present. List after 3 weeks.
Obliged.
Sir, where are you?
Notice may consider the case of the petitioner. In the event the petitioner takes a corrective measure. Then the rest will send. Impute orders are issued in the interest of public and administrative exigencies by way of the executive instruction or orders which are in consonance with the provisions of the law and same are not contrary to the provisions of recruitment rules. And as such, there is no scope of interference to such an executive instruction, which is not illegal. I find no merit in the writ petition and the same stands rejected. The impugn orders are upheld. However, it is provided that the respondent authorities is at liberty to reconsider the case of the petition. In the event it is found that the petitioner is not involved in any encroachment, damage and abatement of encroachment of government property and the government land, NOC may be issued to the petitioner. Sorry.
My lord, I may
Yes.
be allowed to move an IA unlisted, which is connected with that contempt matter. I have already filed the amended petition. That amended petition is to be brought on record. That's all. And issue notice on that.
Let us see whether there will be.
IA and then contempt.
Lordship, I beg to mention item number 18.
18.
Yes, Lordship. Senior counsel is in out of station, so this matter
It's
may be.
2014 matter.
Yes. This is very old case. Senior counsel is out of
It's a
station.
termination, dismissal,
Lordship,
dismissal from service. I think
Uh,
this should be the one of the oldest cases. Anyway, MS. MS Swenso, learned counsel, appearing on behalf of Mr.
Mukpatin, sir.
M. Pertin, learned senior counsel. Learned counsel to the petitioner. Submits that senior Mr. Pertin is indisposed today, for which he prays for listing the matter after 4 weeks.
Vacation. After vacation, Lordship.
After 2 weeks. Praise the Lord. This matter after 2 weeks. In view of the considering the matter is of 2014, the adjournment is granted as a last chance. 2014 matter.
Lordship, I'm mentioning item number 14, Lordship.
14.
Yes, Lordship. Lordship, this matter will be kindly adopted today as the main counsel is out of station.
You are Mr.
This Sankhya.
This okay. Learned counsel for the petition. Learned counsel for the petitioner. Submitted. Press bond is granted. Press for listing the matter after
3 weeks, Lordship.
3 weeks.
And for respondent number 4,
Mr.
K. Parag.
So and so appears for respondent number 4. Has no objection. Please. Praise the Lord. List this matter after 3 weeks.
3 weeks.
Mr. Lordship.
May I, Lordship?
Yes.
I beg to mention item number 8, my lord.
8.
Yes, my lord. Here, the respondent have to file an affidavit.
Yes, ma'am. For respondent number 4, we have filed for receipt, but for food and supply, we need some more time, Your Lordship. We have received the instruction, but it's not complete, Your Lordship. So at least 4 weeks time may be given, Your Lordship.
On the prayer of MSP Pangolan State Council, who submits that the affidavit, an affidavit of opposition on behalf of respondent number 3.
Yes, 1, 2, and 5, Your Lordship.
You would like to file 1, 2, and 3.
No, 5, Your Lordship. For respondent number
uh,
3 and 4, we have already filed, Your Lordship.
An affidavit of opposition on behalf of respondent number 3 and 4.
No, 1, 2,
has-
and 5.
Huh?
1, 2, and 5.
Which affidavit you have filed
Oh,
already?
3 and 4, Your Lordship.
3 and 4. However, see press for 3 weeks to file affidavit on behalf of respondent number 1, 2, and 5.
Yes, Your Lordship.
1, 2, and 5. As allowed. List after 4 weeks, 3 weeks.
Yes, my lord. My lord,
Mr. So and so.
in item number- yes,
You are
sir.
respondent petitioner.
yes, my lord.
Mr. So and so. Learned counsel appears. Learned counsel petitioner is present.
Also, my lord, item number 12 and 13, my lord.
12 and
We have taken consent from the other party also. Kindly,
On the
note
prayer
on the
of
page, Lord.
Mr. So and so, learned counsel for the petitioner. List this matter, list this matter after 3 weeks.
Yes, my lord. Much obliged.
Lordship, I beg to mention one unlisted IA in WPC 167/2024.
What is the urgency?
Actually, Your Lordship, in last occasion, we forgot to mention the interim in the man petition, so it's for interim.
Okay. At 2 o'clock.
Okay.
May Your Lordship, I beg to mention item number 15 on behalf of N. Pada. I'm the petitioner here and I have taken consent from the other side.
Item number
15,
15.
yes, matter may be adjourned and listed after 3 weeks, Your Lordship.
Mention has been made on behalf of Mr. N. Pada,
Yes, Your Lordship.
learned counsel board of petitioner, that the matter be adjourned
Yes, Your Lordship.
for 3 weeks.
Yes, Your Lordship.
Praise the Lord. No, list the matter after 3 weeks.
Mayor, my lord. My lord, I would like to mention WPC number 70 of 22 and 71 of 22. This on 15/3/2024, Your Honor. By order dated 15/3/2024, the matter has been fixed for, my lord, on 19th April of 2024. There is a clash, my lord. On that day, voting would be there. So there would
So
be no
it
vote.
will be listed after that. There are
I'm praying for 30.
30.
30 April. Yes, obliged.
May I, Lordship?
Yes.
Lordship, I beg to mention item number 6, Your Honor. Here, Lordship, same analogous matter has been pending before this principal said, Lordship. I think it has been transferred. It was supposed to be listed with WPC 1286 April of 2016, Lordship.
Yes, what do you want?
Matter may be adjourned and may be listed together, Lordship.
Mr. B. Taipudia, learned counsel appearing on behalf of learned counsel for the appearing on behalf of Mr. RCK, learned counsel for the petitioner. Press that matter be listed after 3 weeks along with
Along-
petition
Along with WPC 1286
1286.
AP of 2016.
1286. It's a number of principles here. How can
Yes,
we
yes,
take
Lord.
together? Has it been transferred back?
Yes, Lordship.
There should be there must be a, new number.
Lordship,
It
order.
must have been renumbered.
I have no idea, Lordship, about the renumbering. But I have got the information that it has been transferred, Lordship.
You find out
Lordship.
the number. If it is transferred, then it must have been renumbered.
Lordship.
You just find it out and give a renumber.
Lordship.
This is 1286.
86.
It cannot be a number of this bench. You find out and
Lordship. Obliged.
My please, Lordship. Lordship, I'd like to make a mention of item number 7, Lordship.
7.
Yes, please, in view of the order passed in the miscellaneous application, this petition will become infructuous.
Where is the petitioner?
I'm for the petition.
You are for petitioner.
Yes.
Oh. Mr. Peter Leonard, counsel for the petitioner, submits that writ petition has become infructuous. Mr. Veridam, Leonard State Council President. Accordingly, the writ petition stands closed.
Yes.
On having been become infructuous.
Obliged.
Item number 3.
May I please, my lord. My lord, this case, brief, like petitioner was earlier working as inspector in the BSF.
Why you have not been included? Yes, why he has not been included? He has been absorbed.
Since this representation is pending before the authority, so that maybe
I have limited period, my lord. The respondent authority may be directed to dispose of my representation with a speaking order with a fixed time, my lord.
Okay. Then you make your submission.
My lord, here I have a limited prayer as of no
Yes.
disposal. So brief fact of the case, my lord,
Yes.
here in the 2004, petitioner was selected as a sub-inspector in the BSF. And since then, he was serving there. And in the year 2010, he went on a deputation in SPG,
Yes.
which is annexure 2, my lord. And in 2010, when he was on a deputation, then their authority gave promotion to the sub-inspector. It's my lord, it's about the 337 number of sub-inspector were promoted to the inspector, which is phase, my lord, 24.
Yes.
Here, petitioner find his himself with the serial number 130, my lord, page 27.
Initially appointed as
Sub-inspector.
Sub-inspector. Then promoted as
Inspector.
37.
Yes, my lord.
Inspector.
Page 27, serial number 130.
27.
Yes, page 27, my lord. Relevant portion.
Okay. 1.
Since my lord, 130, my lord, 130, serial number 130.
Milotali.
Milotali. Yes, my lord.
Milotali.
Yes, my lord.
Yes.
And at that point of time, he was on a deputation with the SPG. And on the promotion of the petitioner, my lord, there at
After the promotion or before the promotion? Deputation.
deputation before promotion, my lord.
During the deputation period, you were promoted
Yes, my lord.
as inspector.
Yes, my lord.
Inspector of what?
Inspector GD in BSF.
Huh?
Inspector GD in
What does it
BSF.
mean? GD.
It's ground duty, my lord.
Inspectors GD.
Yes, my lord. And at that point,
In BSF.
yes, my lord.
Okay.
And at that point of time, my lord, the petitioner was holding as SO2 in SPG.
Is it necessary?
No, I'm just
How you have been absorbed?
no, my lord. Initially in 2018, I was offered for deputation by the state state government, which is at my lord. My lord, phase 36, annexure 5. I was offered to take me as a deputation in the Arunachal Pradesh police as an inspector and civil police, my lord. May I read, my lord, order?
Yes.
Offer letter, my lord. The governor of Arunachal Pradesh is pleased to issue offer of appointment to Sri Milotali Inspector BSF number such and such of BSF by Government of India, Ministry of Home Affairs, Director General of Border Security Force, New Delhi as Inspector Arunachal Pradesh Police on deputation basis for a period of 3 years with effect from.
It's okay. There's no dispute then.
Accordingly, my lord, my authority, BSF authority also granted NOC.
Yes.
Which is page 37, my lord.
Yes. Then
First paragraph. Then, my lord, at that point of time, I was attached with Office of the Minister of State for Home Affairs. They also given me, my lord, discharge. They relieved me from the duty. Page 39, my lord.
yes.
Then, accordingly, as per my lord, upper letter, I have joined, reported to the Director General of Police, which is page 40, my lord. And since then, my lord, I was there on the deputation. Then respondent authority made a proposal that they are willing to absorb me in Arunachal Pradesh Police as inspector. Here, respondent number 4 has sent a letter to the Undersecretary Home. Page, my lord, 41. Again, my lord, Director General of the Police again recommended my name for the absorption in Arunachal Pradesh Police. Page 42, my lord. Last second paragraph, my lord. The case of the Inspector Milotali is being recommended for absorption in Arunachal Pradesh Police in view of his service experiences in SPG and BIP security, my lord. And again, on this, my lord, my authority, BS Parent Department also granted NOC, my lord.
Yes.
Page 43. And then, my lord, finally, I was absorbed by order dated 24 February 2023. Page 44, my lord. May I read the order, my lord? Absorption order.
Yes.
In pursuance of the letter number such and such, dated such and such of the Joint Secretary Home, Government of Arunachal Pradesh, Civil Secretariat, Itanagar, Sri Milotali, Inspector, BSF is hereby permanently absorbed in Arunachal Pradesh Police Civil with effect from 24 to 2023, my lord. So, my lord, since then, thereafter, my lord, I was directed to submit a technical resignation, my lord, from Foreign Department. Accordingly, my lord, I have submitted my resignation, page number 45, my lord.
Yes.
Request for technical resignation with lien, my lord. Thereafter, my lord, page 46, wide order dated 14/3/2023. On my submission of a technical resignation, my Foreign Department struck off my name from the BSF.
Yes.
And thereafter, my lord, I've been, I'm serving in the Arunachal Pradesh Police as inspector.
Yes.
And presently posted at security cell. And in the month of September, my lord, I came to know that final seniority list of the inspector of Arunachal Police was published, my lord. And when I'm gone through, but I find my name is not there. So being seniority list is, my lord, page 55.
Why you have annexed the recruitment rule?
No, just to show, my lord, there is a provision for absorption of a deputationist, my lord.
Where it is? Is there any
Yes, my lord.
relevancy? Is it relevant?
Just to indicate, my lord, there is a provision for absorption of the deputationist in the post of inspector.
That's all.
That's all, my lord.
Anything more than that? When you are absorbed?
Yes, my lord. Here, my lord, as per recruitment rule, 75% is to be by the promotion and 25% is to be from the deputation, my lord.
Telling which by promotion.
Yes, my lord.
Then, page 55.
Then, my lord, this seniority order came, my lord, was finalized, my lord. It appears, my lord, in the month of earlier they circulated provisional seniority list when I was not observed. But seniority provisional seniority list has been finalized by this order, my lord. May I read, my lord, order?
Yes.
The government has circulated provisional seniority list wide such as 6 December 2022. 2022, my lord, before my permanent absorption, inviting claim and objection, if any, from the aggrieved individual within 30 days from the date of notification. In total, 5 numbers of representation received, 3 from IRBN and 2 from APP Civil. In representation were forwarded to PHQ for their comments. Accordingly, the comments observation from PHQ received and examined thoroughly.
It's okay. This claims and objection is before your objection.
Yes, my lord.
This final seniority list has been prepared on the basis of all those the claims and objection issued way back in 2022.
22, my lord.
Obviously, you'll be included.
No,
on
my
the,
lord.
on the next.
But seniority list has been published much after my observation, my lord. I was observed in the month of February.
No, the official they what is their stand?
Actually, my lord, they are not responding my representation. That's why I am before this honorable
We'll
court,
issue
my lord.
notice. We'll say the pendency of representation shall not be a bar.
May I pray, my lord, the respondent authority to directed to dispose of my representation with speaking order, my lord.
Then when according to you, if you are included, which slot you will be?
I will be my lord. I will be in number 2, my lord, because since 2000.
That is the reason. That is the reason. That is the reason.
So no things that, my lord, now they are neither denying me or responding my representation, my lord. They are not saying anything.
You will be in number 2.
Yes, my lord. If my past service has to be counted.
Yes, that is the things to be considered.
Yes,
we would like to give you a full relief. Obviously, you'll come back.
Yes, my lord. First, let the respondent authority decide whether they want me to.
No, I believe in all this thing. It's like you cannot be a post office.
Yes, my lord.
If we grant a relief, it should be a relief.
Yes, my lord. It will
What do
be,
you
my
say?
lord.
Because Lordship, why I propose for directions to consider the representation Lordship. Because Lordship, mind of the authority is not discernible from the Lordship records Lordship. So mind of the authority Lordship. Why Lordship he has not been given the
because they have considered on the basis of the claims and objection published in 2022. That has been examined. They have received all these things before his absorption. Then accordingly on the basis of those records, the final seniority has been he ought to have been included once he is absorbed. That is another thing. But records on page 55 clearly says on the basis of the provisional seniority list,
No, my lord,
where claims and objections were invited.
The or other candidates is okay, Lordship. So, but the petitioner's case, Lordship, because it's not discernible, Lordship. The mind of the authority, why, Lordship, he has not been given that position, Lordship. So only to
Okay, heard Mr. D. Laji, learned counsel for the petitioner. And also heard Mr. Estafid, learned senior government advocate. For all the respondents.
Yes.
For all the for all the response. When please stop, huh? In view of the nature of the prayer made by in view of the nature of the prayer made in this application and on consent of the no. And as agreed to by the learned counsel for the parties, the present petition is being disposed of at the motion stage. Next paragraph. The grievance of the petitioner is for non-inclusion in the seniority list of inspector within brackets civil police.
Yes, madam.
Within bracket clause, which has been published by file number, page 55, dated 13/09/2023. The petitioner has prayed for a direction to dispose of his representation dated, where it is?
Page 62, my lord.
Dated 20/09/2023 for inclusion of his name in the MPN seniority list by taking the first service rendered by before the absorption as inspector within police in the Arunachal Pradesh Police. Next paragraph. The petitioner was appointed as sub-inspector, right?
Yes, madam. Initially.
On 29/10/2004.
Yes, madam.
2004. And he was on deputation in SPG.
SPG, madam.
SPG and SPG.
SPG at that time, SPG, madam.
SO. Security officer. Dash Roman 2. Listo. So during the period of his deputation, he was promoted to the post of inspector. Inspector is on
31/05/2010.
31/05/2010.
Yes.
Christopher. Next paragraph. In the meantime, where is that offer? Offer letter
Offer letter.
for deputation.
Page 36, madam.
the, no, well, he was serving as inspector in the BSF,
Yes, my lord.
BSF under the Ministry of Home Affairs,
Yes, my lord.
Government of India, government. And on deputation as SPG, as a security officer. When this offer came, you were on deputation.
No, no,
as
my
sec-
lord. I was in parent department, my lord.
Okay, serving as inspector, so and so, huh? On being promoted, comma, the wide order dated 03/10/2018. An offer was given to the petitioner by the state of Arunachal Pradesh to join as inspector within brackets civil police in the state police department. Accordingly, absolutely. Completion of codal formalities. He was he joined as inspector within brackets civil police in the Arunachal Pradesh Police Department from BSF. But later dated, this is page 41 is 2009
Yes, my lord.
2019.
2009, 2019.
The Assistant Inspector General of Police within bracket E, Arunachal Pradesh has sought for an address to the Undersecretary within bracket Home Government of Arunachal Pradesh. Stating the willingness to absorb the petitioner in the Arunachal Pradesh Police Department. Thereafter, by letter dated 19/05/2021, the petitioner was recommended for absorption as inspector within the civil police, bracket close in Arunachal Pradesh Police. According after codal formalities and on acceptance of the technical resignation with Lian, where is the absorption order?
Absorption order, my lord. Page 44.
44. Wide order dated 24/02/2023. When the service of petitioner as inspector within bracket civil police has been permanently absorbed in the Arunachal Pradesh Police in the post of inspector within bracket ex-cadre post bracket close. It is contended by the petitioner that while serving as an inspector No, no, not when, contended by the learned counsel for the petitioner. That the petitioner is at present serving as Inspector Civil, within bracket civil, civil police bracket close in the Arunachal Pradesh Police Service on being permanently absorbed. Mr. Hauba, by order dated 13/09/2023, the authority has published the seniority list of Inspector Police, whereby published the seniority list, final seniority list of inspectors within brackets, civil police, wherein the name of the petitioner has not been included. He submits that since the petitioner has been permanently absorbed in the police department after following all the coded formalities, the petitioner ought to have been included in the seniority list in an appropriate place, considering taking by giving the benefit of his first service in the BSF as inspector list of. He submits that he has filed the representation. What is the representation?
Page 62, my lord.
62
Yes, my lord.
on 20/09/2023. However, same has not been attended to. Come on. Mr. Next para, Mr. Estafil Lanet, Senior Government Advocate. Submits that. What is your submission? This
Let the
nothing
authority-
is discernible. Why he has not been?
Lordship, therefore, Lordship, let the authority
That submits that nothing is discernible from the materials annexed in the writ petition as to why the petitioner has not been included in seniority list of the inspector or the advocate civil police in the Arunachal Pradesh Police, as the petitioner has already been permanently absorbed in the department by following due process. List. Next paragraph. I have considered the submission of learned counsel to the petitioner. I have considered the submissions of the learned counsel to the parties, and there is the materials annexed to the writ petitions. Next paragraph. On perusal of the materials annexed in the present petition, it is noticed that the petitioners, who was initially as appointed as sub-inspector in the BSF and promoted to the post of inspector, was offered the post of inspector within bracket civil police in the police department, in the Arunachal Pradesh Police Department. Accordingly, after following due procedure, the petitioner has been absorbed permanently in the department. Mr. Next paragraph. Having considered the above, comma, this court is of the view that the petitioner is entitled to be included in the seniority list of inspector within bracket civil police bracket clause of the Arunachal Pradesh Police, as he has already been permanently absorbed. He has been permanently absorbed after due process. Following the due process. Mr. Next paragraph. On the bare reading of the order dated 13/09/2023, issued by the Principal Secretary within bracket home, Government of Arunachal Pradesh, whereby the finance seniority list of inspector within bracket civil police has been published. It transpired that the final seniority list has been prepared on the basis of the claims and objections sought after publishing of provision seniority list on 6th December 2022. List of the authority appears to have considered the records only on the basis of the claims and objections submitted by the inspectors, the officers of the officers on the claims and objections and the provisional seniority list published on 06/12/2022. Mr. However, since the petitioner has submitted the representation, it is incumbent upon the respondent authority to consider the representation of the petitioner. Mr. As noted above, next paragraph. On the consent of the learned counsel for the parties, comma, and having considered the nature of the prayer basically for disposal of his representation, comma, this court deem it appropriate to dispose of this present petition at the motion stage. Mr. Next paragraph. Accordingly, the present writ petition, the writ petition is disposed of with a direction to the respondent authority, particularly the principal secretary.
Yes.
Principal secretary will decide.
And
respondent authorities, particularly the respondent 2 and 3, namely Principal Secretary Home so and so, and the Director General Police so and so, to consider and dispose of the representation of the petitioner. The representation dated 20/09/2023. filed by the petitioner. And pass an appropriate orders within a period of 1 month.
3 weeks, my lord.
Huh?
1 month.
1 month.
1 month
With my
Okay.
lord, speaking order, my lord.
from today. Huh?
Speaking order, my lord. Dispose of with the speaking order, my lord.
Obviously, they'll pass an appropriate orders. Speaking order.
Yes, my lord. Sometimes they just reject it without any assigning. Without
Pass
any
a speaking order.
Hmm.
Within a period of 1 month from today.
Lordship, one lordship. Here, lordship, representation has been filed before the respondent number 3, lordship. And lordship is directing the respondent number 2 and 3, lordship.
He has filed a representation.
Before the respondent number 3, lordship.
Who is respondent number 3?
3 is the lordship, DGP, lordship.
2 and 3.
You find
Copies are given earlier.
the next continue. Since the petitioner has filed his representation before the respondent number 3, I Director General of Police, Arunachal Pradesh, is directed to file a press representation before the respondent number 2, I the Principal Secretary within Bracket Home, Government of Arunachal Pradesh, within a period of 2 weeks. I mean, within a period of 1 week.
Yes, ma'am.
From today.
Lordship. And earlier direction to these 2 respondent, lordship. Direction may be to the respondent number 2 only, lordship.
No, my lord. Earlier also. I
Because
have in
2
fact-
authority cannot take decisions on the same issue, lordship.
No.
One is a higher
No,
authority.
that will be decision will be by this will be moved from the bottom, then decision will be taken by the principal.
This
Yes,
ca-
my lord.
this-
Anyway, we'll direct the respondent number 2 only.
Lordship.
All right.
Anyway, my lord.
We're not commenting on your entitlement of past service, huh?
Oh,
You may file a better representation.
yes, ma'am. Most obliged.
Item number 4.
Yes.
Yes, my lord. Petitioner here is challenging the letter of the intent issued to the respondent, private respondent number 9 by joint director. Respondent number
Just
2.
wait. Caveat, there's a caveat. Add MS and Langan Counsel for the caveat. Caveat is still the church.
Yes. Representing director.
What is the status now?
Now, actually, last occasion, some error was there.
Work has been awarded.
Work is not awarded. Only intent, a letter of intent, which was supposed to be issued in favor of.
And 6th of March to 2024.
Yes.
Today we're on April. It's been more than a month.
No, yeah, my lord.
What do you say? Work has been, contract has been awarded?
No, my lord.
Then will you stay?
No, my lord. What I say, my lord, there is a technical problem.
My lord,
Let
let me complete.
May I, my lord?
Just wait.
Yes, my lord. In the earlier writ petition, my lord, the first writ petition of WPC 154, the private respondent has filed one IA. my lord. In the IA, they have reflected this order, my lord.
It merges along with all those. It has been disposed of.
No, my lord. What I am saying, this order on 5 March of 2024,
Yes.
the scrutiny made in that directorate, my lord, headquarters, my lord,
Ah,
which has not been challenged by them, my lord.
okay.
This is in their knowledge, my lord. This IA, my lord, it is
So
in
we'll
the
let you
record.
notice the you are not saying that the re-evaluation or the second
Yes.
scrutiny by in the directorate
Ah.
is not permissible. That is not your challenge.
That's
Right?
why I'm coming back.
So if they have that authority
Yes.
to re-evaluate and re-scrutiny and have a in the directorate level, unless you put to challenge that, it's very difficult. We'll issue notice. That's all.
My lord.
Yes. My lord, this may be called, those,
You furnish the copy to
a
her.
copy.
Well, it is with them, my lord. This is the IA file in the first
Why not-
petition by the private.
Yes.
respondent.
Gone,
That
it's
is
all
over.
gone. We're not calling.
No, my lord, the letter
So,
of intent, which
my
is
lord-
impugning, is based on this order, lordship.
That's what I'm saying.
Yes,
They are not challenging.
yes.
See, you have been recommended
Yes,
as L1
yes, L1,
by
L1.
in the district.
Yes,
Then when it reach here at
Yes.
Itanagar, which is the headquarters,
yes,
who is the authority to decide
yes.
everything.
No, actually, Your Honor,
Just
my
wait,
lord,
just
here,
wait, just wait. They have re-evaluated it. And I don't know, it's a re-scrutiny or they have scrutinized the tender, all thing, because before that, if you, is it your, are you challenging that they don't have an authority to re-evaluate or cannot have a second scrutiny? Is it your case?
yes.
Huh? What it
Uh,
is, what you have
No,
to,
here, actually, my lord, here, private respondent,
your simple case is that you have been recommended by the
yes,
this tender evaluation
Yes.
committee in the district
yes,
as L1.
yes,
When it was sent here for the approval, the respondent number 6 has been given the LOI. On that, they are saying that they have re-evaluated it, which they have the authority. Therefore, they found that it was not correctly, you are not the L1,
no, my lord, here,
or you are not entitled to be awarded. It is the respondent number 6. It's a final authority.
no, no, my lord, like this only, your joint director have nothing to do. First,
It's
the,
not individual
Yeah.
officer.
yes, your potent,
What they are saying is district level, there's a one
yes,
committee.
yes,
And then when they, after the scrutiny or evaluation,
yes,
evaluation at district level, it
Yes.
comes here
yeah,
in a directorate level.
yes.
Then they have a committee and they
Right.
finally scrutinize and
No,
they'll
my
get
lord,
the authority.
my lord, like that only.
Yes.
We have finally from district, three L1, L2, L3 was selected.
Yes.
But out of that, this private respondent, it was out of that. But now this very shock and surprise, where his name is not being recommended by the district, the authority, while there was a scrutiny. But what happened here? It's very surprised. The respondent 9 has issue. His name has a issue. His name has been recommended to be issued the intent letter. So that is my challenge. So his name was not there at all. His name was not at all recommended. So how come the whose name was not there? Three of L1, L2, L3 was.
That is what they are saying.
Yes.
Though there may be a recommendation by the district level, they have the authority to decide finally.
No, my lord,
By
yes,
by examining all the records.
yeah,
When they found that when they examined the records, since they have the authority to decide,
no, it's
they have
correct.
decided in favor of the
But-
respondent number 9. That is their stand.
My lord, it's correct.
The point
Yes.
which this court is making is that whether you have the query, in fact, whether you have challenged the authority to re-examine in the directorate level.
Yes,
Are you
re-exam.
challenging it?
Yes,
Where
re-exam.
it is. In that case, you have to challenge the where it is, the scrutiny of the, in the order of scrutiny or the
In the directorate level, my lord.
directorate level.
5th March.
No, is it in annex?
No, my lord.
No, that is precisely I'm
Yes, my lord.
asking you.
They had that knowledge, my lord. They had knowledge of this order.
My lord, L1 was not been not given any notice here, even the joint director level.
See, it is not required according to them. Since the final authority, they have the authority to scrutinize
No,
again and re-examining and finding out where the
my
authority.
lord,
finally
that's why I'm
decide.
coming, my one point. Here, actually, those who have not been selected, my out of three of us, L1, L2, 3. But this joint director, they should evaluate, re-examine whether three of us, which one is the better.
What is the law?
Now,
What is the condition?
as per
What is
the
the condition?
as per important, as per
Where is that condition?
as per NIT plot, yes, Article 14, that is
If you go,
yeah,
if you go,
my lord, finally,
if you go like this, it will take 100 years
yes, yes.
to find out.
Actually, I'm not much familiar in this High Court. We are really coming in this. So, my lord, this is my page number, the
Page?
51 in this.
51.
Yes,
51.
Article 14, awarding of the work order.
51. Yes.
Yes. Here, my lord, yes, say that the tender shall be evaluated by the board, considered by DC, DPC at district level. And I recommend at least 3 firm, L1, L2, L3. This is to competent authority. That is joint director. After recommend from the district DC, DPC, so this recommend goes to the joint director. Then only joint director can act. They can call the record. L1, L2, L3.
Yes, read it.
Yes. Joint director shall be para scrutiny the tender document recommend by project director. The L1 will be L1 will be issued to LO1 will be issued to,
LOI.
LOI. L1
LOI.
form if the tender document recommended by the project are up to the satisfaction of explained authority.
Yes.
This is so as per the Article 14, the clause 1, it is clearly said that already the DC level, the district level have already recommend out of 3. In spite of the recommend 3 of them, those who are not in the
number 9 was
not in
recommended.
the this one recommend. In spite of that, it's very shock those who are not in list, he was recommend to award the.
You were recommended, you and 2 others.
Yes, three out of we have 3.
You L1 and two others. 1 and 2.
We have 3.
Were recommended by the project director.
Yes.
Which the joint director have the authority to further scrutiny.
Yes, out of 3, the contender.
According to you.
Yes. As per this, I'm not saying, as per this, the Article 14 says.
It has an scope of reading too many interpretations. And there's you read the next line.
Next line. The joint director, Ari, clause Ari, shall further scrutiny the tender document. Recommend project director. The LOI will be issued to L1 firms. If the tender document recommended by project are up to the satisfaction of exempt authority.
What does it mean by recommended by project? I
Project
think
means,
director
project
is
means
missing.
district DPC.
Documents recommended by the project.
Yes, DC,
This means project director, I think it's missing.
DC,
up to the
this in
satisfaction of-
district level, DC.
That's why I'm saying it is lots of scope to read into and read down. You said when nothing is there, you
Oh,
have
that's
to.
why, my lord, we don't have a record and all, no. Please, this honorable court may recall the record.
No, what I'm saying is, this is what? If the tender documents recommended by the project are up to the satisfaction accepting authority.
Yes.
If not,
If not, three of us, those whoever may be, they recommend. If one is not satisfied, the second may be.
so I think, do you agree that the word the director is missing here in the last line?
No, as per, as per, my lord, here, as per, they have made the manual, as per rules.
There could
I'm
be
going-
there could be a mistake also.
No, this is, not-
Typographical mistake.
that's why, my lord, the record may be called,
In fact, I am with you, but then is it, I think, recommended by project means what? It doesn't make any sense unless you,
project,
unless you read into the director,
yes,
right?
project director, project director,
So we'll issue notice.
yes.
That's all.
Till that, the work order may be
No.
not issued.
That is the problem I am hearing you. For that only.
That's why.
Okay, will, anything else? No.
Yes, yes. This much.
Yes.
My lord, that is why, my lord, if not, my lord, this order, my lord, was placed before them, my lord, on the last occasion also. It is within their knowledge, my lord. It is not,
What about this page 51? What do you say about this?
this interpretation has been made in the 5 March, my lord, that order, my lord. It is there, my lord. All the documents were called for, my lord.
It is in respect of
Talia.
Thalia.
Yes.
Thalia.
Talia.
Taliha.
Yes.
Taliha and Payeng.
Only Taliha.
Thalia.
Taliha.
Fine also.
It's okay. Whatever this clause 14.
Clause 14, my lord, what happened, my lord, we, as per the instruction, we came to know that the justified person has been ignored, my lord. My lord, may I please come to page 68. Now, to avoid litigation, my lord, we have called for the records of other bidders also, my lord. Page 68, my lord, serial number 5, my lord, MSRT Enterprise. As per the, my lord, this amount quoted by the private respondent, 1 crore 65 lakhs 36,101, my lord. It is apparent that he is the L1, my lord.
Which one?
My lord, down below, yes, RT Enterprises, yes, my lord.
NIT amount less than 165.26.
It is less than other bidders, my lord. So we could not have ignored. Now, second thing, my lord, while preparing, my lord, while preparing the justified, my lord, justified rate, my lord. As per my instruction, my lord, the justified rate has to be, my lord, approved by the competent tender accepting authority, my lord. Now, no such approval has been taken by the authority concerned, my lord. So, why, my lord, this strict principle of variation of 10% is not applicable in this case, my lord.
No, that is by your officers only in the district level.
Yes, my lord.
How do you come to know that this has been done?
This is the board proceeding, my lord, page 68.
Yes, this is before by the board proceedings by the district level.
District level, they send these documents to the headquarter level, my lord. Headquarter, my lord, Itanagar, my lord. Then we analyze the documents, my lord. On analyzing these documents, we found that the L1 has been left out, the original L1, my lord. So we called up all the documents. My lord. It is reflected in 5 March of 2024, my lord.
But they are saying that this variation of 10% applies. Is not it?
We say, my lord, it will be applied when, my lord, the district board, my lord, take approval from the competent or accepting authority, my lord, the rates, justified rates, my lord.
But what about this page 51? You read and explain.
Yes, my lord. For that, my lord, I say, my lord, page 68 would be relevant, my lord. What we found that L1 has been left out. So we call up all the bits of the my lord, of the district, my lord, of this concerned CD block, my lord. So on analyzing the bid documents, my lord, we found that yes, private respondent is the L1. It is apparent from the record, my lord.
What he's saying is,
yes,
you cannot ask for other documents, other the bidders, I mean documents of the day. Only you can ask for you have to scrutiny the documents, standard documents recommended by the project director.
What we say, my lord, we cannot blind ourselves, my lord. We cannot blind ourselves, my lord. We have to see, my lord.
Okay, it appears to be fair enough, but then fair, but then what you have put a condition?
My lord.
Why you have put this condition?
Condition for, my lord, for transparency, my lord, but they have not followed the transparency, my lord. That is why, my lord, we came across. No, not the petitioner, not the petitioner. District board has not recommended
It's your,
the
it's your officer only, it's you
Yes, sir.
only.
That is why we
within you only.
Yes, sir. That is why we
Which
corrected.
under you only.
Yes, my lord. That is why we have corrected it, my lord. By calling all the reports, my lord.
But then if the variation of 10% is, I mean, applicable, petitioner is L1.
What we say, this justified rate has to be prepared, man. So when the district board prepares a justified rate, it has to take approval from the accepting authority.
It's okay.
Yes, madam.
Let us forget it for a time being. It is approved, justified rate.
Not approved, madam.
No, if it is, let's assume.
Yes, madam.
For a time being.
Madam.
If it has been approved, you have to go by the justified rate.
Yes, in that case,
in that case is L1.
Yes, madam. In that case,
we'll decide that. No further. Okay, yes. We'll issue notice and stay for a time being.
Yes.
Because no further, don't take the process. Because what they are trying to justify
Yes.
is that we don't know. I mean, as of now, and the petitioner also doesn't know, and you yourself also, whether the justified rate and all these things has been approved or not. They put a condition,
Yes.
page 51,
Yes.
saying that the joint director
Yes.
has the authority to scrutiny,
Yes.
further scrutiny to the tender documents recommended by the project director.
My lord, my lord, in order to, it would seem like I'm repeating his argument, but my lord, page 51, which my lord has pointed out,
Yes.
says that after all, it is the joint director who is the final authority for acceptance.
Yes.
My lord.
Yes.
Now, what happened at page 68, my lord?
Yes.
What happened at page 68 is the board, the recommendation of the board at district level. it is apparent from this that the respondent, private respondent is the L1. Lordship. Now, if they're limiting, saying that only the recommendation of L1, L2, L3 should be sent, it is just like saying that you make all the mistakes and you have to conform to our mistakes. That considering that the JDRE is the final authority.
But then it's not,
that much of leverage
no,
is Lordship.
the
found.
district board has they have a basis.
Lordship.
Basis is what? Justified right.
There is no justified right, Lordship, because it has not been not been approved, Lordship. In the absence of a justified right, where is the question of 10% or below 10%? The whole case depends on the if their whole case depends on the justified right. In the absence of any approval, how can we say that
Where is
this
the
is true?
requirement of approval? Where is the requirement of approval?
Justified rate. For justified rates, there has to be a rate, Malad.
Yes.
After preparation of justified rates by the district board, Malad, they have to take approval from the competent authority. Malad.
Where is the requirements? Under what provision?
As per my instruction, Malad.
Not your instruction. It's
No.
okay. Maybe your instruction, but what is the other what is the provision?
In that case, Malad,
Any guidelines?
guidelines, Malad, I have to seek written instruction, Malad. In next date might be fixed so that
Why am I saying that it has to be approved?
it
Why
Malad,
is the requirement of approval?
because justified rates, Malad, they can make any rate, Malad, the board, district board, Malad. So it has to be in concern with the district headquarters. Malad, what happened, Malad? These places like Daporijo, Malad, it is in the town. Dumpurijo, it is in town, Malad. Taliha, it is in interior place, Malad. So there has to be some analysis of rate, Malad. These are not within the town, Malad, place. Malad. It is outside the in the interior places. Malad.
That's the I think that's the I mean fairly they have done that because of that only.
Malad.
What this justified rate means?
Justified rate, Malad, the market value of the rate, Malad, applicable to the concerned CD block, Malad.
Total misconception.
No, Malad. See, suppose, Malad, is a 1 bag of cement, Malad.
It's not a market value.
Market rate, Malad, market rate.
It's not market rate. Anyway, we'll issue notice.
My lord,
Are you working, executing the work? If you are executing, will not stay. But
we
if you are
are in the process of executing the agreement, Lordship.
Not yet.
well, in that case,
Also, Lordship, I would like to point out, Lordship,
yes.
that the order which is impugning the letter of intent,
Yeah.
there has been issued on the basis of the order dated 5 March, Lordship. That has not been impugned, Lordship. That has not been challenged.
Yes, they don't have any knowledge. They have the knowledge. They have to challenge it.
Also, I would not like to, I wouldn't have want to point out again and again, but again
So-
here, the state of is represented by the director.
It reminds us the observation and comments of Justice K. Meruno. You cut the root, not the branch. He's trying to cut the root, the branch.
Lordship, again, the main party is the state is represented by the director, Lordship, again. Page 3, Lordship. I know this is a clerical mistake, but
Why a mistake after mistake?
so not even notice actually cannot be issued, but I'm not going to object seriously here.
Yes. There cannot
No,
represent
yeah,
mistakes.
actually,
It's not below the rank of secretary.
My lord, that's why I have met all the parties, those from
No.
top to
State
bottom.
has to be represented not below the rank of secretary of this.
No, state must be represented by the secretary.
Hmm.
So
Do you
maybe
agree?
yes.
Then
Yes, secretary must be.
huh?
Secretary is the authority. main authority.
Then-
And government, secretary is government.
Hmm.
But then I make top to bottom, those who may be involved in this evaluation.
Sir, it's not that. You'll have to properly. It has to be in accordance with the procedure, not just what you would like to have. Heard, Mister?
Tidukom. Tidukom.
Learned counsel for the petitioner. Challenge made in the state petition. Challenge made in the prison application is the letter of intent. That is 06/03/2024. Page, where it is? Where is it? Where it is? Page, letter of intent,
No, letter of intent.
69.
69.
69.
Yes.
Issued by the Director, Rural Development, the Rural Development Department, Government of Arunachal Pradesh, in favor of to the respondent number 9, namely Messrs. Aarti Enterprises, Taliha, Upper Subansiri District, Arunachal Pradesh, on the ground that the respondent number, the respondent number 9 was not recommended by the district board. And it was the district board, Mr. The petitioner along with 2 other bidders being L1, L2, L3 were recommended by the district board, tender evaluation, district tender evaluation board. Next one. The learned counsel for the petitioner, referring to clause 14 of the, what is this? It's a part of what? SBD or what? Tender document.
SPD.
What is this? Yes. Peter, what is this? Page 51 is a part of what?
Page 51 now.
Yes, this clause awarding work. Is it SBD or what do we call it?
My lord, it is in the NIT, my lord.
Is it part of the NIT?
Yes, my lord.
Referring to the 14, clause 14 of NIT. Dated. When was the NIT?
It starts to page 26, my lord.
Page 26.
27 January 24. Page 28, my lord, would be relevant now. 28.
Dated 27/01/2024. Submits that. The joint director within bracket RE is authorized to further scrutiny the tender documents recommended by project director. Mr. In the present case, the petition, the joint director appears to have scrutinize the tender documents of all the bidders, which is not permissible under the condition in the permissible. Which is contrary to the tender conditions. Mr. He further submits that the petitioner is found to be was recommended being L1 on the basis of the justified rate as well as variation of amount quoted in the tender. Mr. Mr. B. Pitcher, Learned Standing Counsel for the Rural Development Department. Submits that the concerned authority, having found that the district level tender, the district level board has wrongly recommended the petitioner as L1. Whereas the respondent number 9 were to be an L1 in view of the amount quoted by the respective bidders. All the documents were all the tender documents of the bidders were have been examined thoroughly and found that the respondent number 9 found the respondent number to be L1. Accordingly, the LOI letter of intent has been issued. He further submits that the basis of recommending the petitioner as L1 is the justified rate applied by the justified rate and the variation of rate quoted by the bidders, which has no approval of the competent authority.
Yes.
Therefore, next para. What is your submission?
End date, that order, 5 March 2000.
No, he further submits that the order dated 05/03/2024. What this order is?
Re-scrutiny, my lord, in the directorate level, which has not been challenged.
For scrutiny of the bids at the directorate level, as per the CPW work manual.
Based on which LOI was issued.
Though the petitioner has the knowledge, no challenge has been made. the order. It is only it is the LOI which has been put to challenge. So, therefore, he submits that the basis of order, unless the basis of order is challenged, the writ petition is not maintainable.
Yes, my lord.
The present petition in its form is not maintainable.
My lord, may I
In the
add
present
one,
form is not maintainable.
may I add one more point? My lord, no writ of certiorari or mandamus has been sought for by the writ petition, but in their prayer, my lord.
Then MS N. Dungan, London, Counsel for the respondent number 9. What is your submission?
My lord. Same as his lordship.
The
Also that proper parties have not been met.
adopts the submission of the London Standing Council for the Rural Development Department. And in addition, she submits that the what is your submission?
Lordship,
What is your submission?
the
Any
state has
addition?
not been made,
Okay.
the state has been made to be
Yeah.
represented by the director, which is not, who is
The-
incompetent.
The present petition is defective in as much as the state is shown to have been represented by the director, which is not permissible under the law.
Under
My
in
lord.
violation of section 79 CPC.
My lord, I have already made all the parties, even though it is not in serial number 1.
Mr. Issue notice returnable by 3 weeks. All right. Having considered the submission, in the interim prayer for interim, heard on the interim prayer. Having considered that the clause 14 of the tender documents, clause 14 of the NIT provides that provides and authorize the joint director for further scrutiny of the tender documents submitted by the project director. And also considering that the district level board has come to a conclusion, have come to a finding on the basis of justified rate and the variation of the quoted rate of the bidders, I deem it appropriate to pass an interim accordingly till returnable date. The tender process pursuant to the NIT dated 27/01/2024 for supply and procurement of materials under MG and Manrega 2023-2024 in respect of Thalia CD block.
Yes.
May not be finalized. List after 3 weeks.
Since the parties are present, my lord, may it be listed after 2 weeks, my lord.
2 weeks. Okay. List after 2 weeks. You want to take
Yes.
it back?
Number 5. There are some private respondent which notice has to be issued.
Okay. Sorry. Issue notice return is 2 weeks. Since the learned, since Mr. B. Picha and MS Danget learned counsel for the respondent number 9 accept notice on behalf of respondent number. What are the respondents you are appearing?
1 to 4.
two?
1 to 4.
1 to 4. And respondent number 9, huh? Find out, respondent number 9.
Yes, our
yes.
private respondent,
You are for 1 to 4.
1 to 4.
1 to 4. No format notice will be served. However, extra copies be furnished to the learned counsel for the petition. A learned counsel for the respondents. Steps for respondent number so and so, huh? Be taken within 2 days by registered post AD, huh? Within 2 days.
God bless you.
Item number 5.
Wait,
yes.
Petitioners are minor challenging the order dated 27/2/2024.
Yes.
Passed by the Secretary Health and Family Welfare, wherein it has been ordered that the selection recruitment process in respect of East Kameng district should be reconducted.
Wait, this. What is the impugn order?
Impugn order is at 107.
107.
Yes. There's a typed copy also, but this is legible enough.
Yes. That copy is.
Type copy is 109.
Yeah.
My lord, kindly come to 110. Serial number 1. There is the advertisement was issued in respect of 12 hospitals, my lord. 75 posts, 8 for SEPALs. Then in order to uphold the recruitment process against the advertisement number such and such, after return test held on 21/8/2023, skill test was scheduled to be conducted with effect from 23/8/2023. However, in respect of District Hospital SEPA and District Hospital Daporijo, the OSCE could not be conducted due to various representations and complaints received from the candidates and other public spirited persons. This is not true, my lord. It was conducted on 23rd. The main ground itself is not correct. It was conducted, but results were not declared in view of a decision meeting by the Deputy Commissioner and other officers. The meeting was held on 23 itself. It was conducted. Thus, the recruitment process remains incomplete. Inasmuch as the skill test could not be conducted. Incorrect. Further, on careful perusal of the records, the recruitment process casted shadow of doubt, thereby causing serious questions of public confidentiality and sanctity during the. Hence, under such shadow of doubt and discrepancy found during recruitment process in respect of DS SEPA and DS Daporijo, there is no other option besides fresh recruitment process to be conducted for filling up contractual nursing officers ICU in respect of both health facilities as such ordered accordingly. The main ground that it was incomplete itself is incorrect. Then your lordship will come to serial number 3. 2 we are not concerned with. It is in respect of something else. That in the absence of any specific or categorical finding supported by any concrete and relevant material that widespread infirmities in all pervasive nature, there is hardly any justification in law to deny appointment to the selected candidates whose selections were not. I'm sorry, there's been double typing. Whose selections were not found to be in any manner vitiated for any one or other reasons. Apart from such, the substantial effort, both in terms of physical and financial, is involved in any recruitment process. Hence, in absence of any incriminating material to substantiate the allegation of any anomalies for recruitment process, hence, in the absence of, I'm sorry, my lord.
Okay.
The allegation of anomalies of contractor nursing officers for such and such, 8 hospitals have been allowed to be complete. There is no material against me also. No material, nothing. The report of DC says so, though he has recommended on some observations. The selection process was conducted in a similar manner in respect of all the hospitals. There is no allegation of, forget about, my lord, any pervasive nature. There is no allegation, no finding against the district hospital SEPA also. So how, my lord, this is discriminatory also, my lord. That is my humble submission. My lord, no, Honorable Supreme Court has, how it has been dealt, my lord, in such matters.
Will issue notice?
I'm praying for some protection also, my lord,
What protection?
because they have ordered for reconduct of the recruitment process.
Hmm.
So that may be, my lord, stayed. Once they stay, they will file immediately. We can, my lord, even before the election process is complete, maybe we can have it
Yes.
disposed of, my lord.
Is there any proposal to, has it not been re-advertised?
No, not yet.
This order is of,
27th of February.
okay. Yes,
My lord, challenge is also made to the recommendation of the deputy commissioner. Lord.
Because, but the impugn order has not been passed in connection with that. But we are challenging that also.
And if my lord sees at page 105.
it's okay, will issue notice, you have not advertised, re-advertised it. Press selection has not yet started.
Yes, my lord.
Will,
That is there.
short 3 weeks, you file the affidavit.
So that,
finish
yes,
it
my
off.
lord.
Nahi?
Yes. What I'm submitting, my lord, is if your lordship grants an interim order, obviously that affidavit will come in 3 weeks. Otherwise, it will not come.
But that,
That is the difficult.
that will not be ground for
But
passing
my
an
lord,
interim order.
my lord, in that case, my lord, I have been in my humble submission. There is a prima facie case for an stay order, my lord.
No, we'll do that. But then that cannot be ground for stay.
That cannot be, that cannot be. But what I'm submitting is,
Yes.
my lord has seen the reason for granting the other 8 hospitals that there is no material. So there's no reason for stopping the selection process. What is the material against us? Absolutely nothing. Same. The only thing they say, the hours is not complete. That is incorrect, my lord. The very foundation is incorrect.
Heard Mr. Deepang, learned counsel for the petitioners.
Respondent.
Challenge made in this application is the impugn order dated 27/02/2024 issued by the Secretary of Health and Family Welfare Department, Government of Arunachal Pradesh. As regards the decision for press recruitment process be conducted for filling up of contractual nursing officers within bracket, ICU bracket clause in respect of district hospital SEPA. Next minute. Mr. Deepang, learned counsel for the petitioner submits that pursuant to the advertisement dated 18/07/2023. What does it mean? TOR.
My lord.
TOR.
TOR.
Yes, page 110.
Terms of reference.
Huh?
Terms of reference.
Terms of reference. And terms of reference issued by the registrar, secretary, APNC, dated 14/08/2023. There was a written examination also.
Yes.
The
on 21st.
The petitioners have appeared in a written examination held on 21st/08/2023 and skill test on 23/08/2023.
Yes.
Thereafter, no, no select list was ever published. Mr. In the meantime, the impugn order has been issued for fresh selection process. What is the selection process?
Yes, in respect of SEPA and
For
the Procedural.
by the impugn order dated 27 to 2024, the authority has illegally decided to go for they decided for fresh selection recruitment process on a non-existent ground. Mr. He submits that the one of the ground for fresh selection process is that the skill test which was conducted on 23/08/2023 wherein the petitioners have appeared from is stated to have been not conducted which is factually incorrect. He further submits that what is this? What is your other?
The second submission is that in respect of 8 hospitals, their selection process is allowed to be completed on the ground that there is no any finding of any widespread infirmities. There is no finding of any widespread in respect of SEPA also.
So further submits that in respect of other district hospitals and general hospitals of different districts, the selection process has been allowed to continue as there was no infirmity.
Yes, there was no finding of any infirmity.
There is no finding of infirmity.
Of all pervasive nature. That is the language.
List of where is the in case of district hospital SEPA, there's nothing to show that there is any infirmity in the selection process. Mr. Hauber, the authority has illegally sought to go for fresh selection without on a non-existent, Mr. Issue notice returnable by 3 weeks. 2 weeks or 3 weeks? 3 weeks.
2 weeks.
2 weeks. 2 weeks you will not be able to. 2
Since,
weeks.
there is going to be an interim order, Malak.
Okay.
Otherwise, only
2 weeks. Mr. N. Ratan, additional Advocate General, enters statements on behalf of the state. Mr. Arkoi London Counsel appearing on behalf of Mr. T. Tagub, London Counsel for the Legislative Council Health Department. For all respondents.
No, I appear for only respondent number 4.
And for 1, 2, 3, 5.
1, 2, 3, 5. One, 2, 3, 5. Then you say, Mr. No, for respondent number 4. since the respondents are duly represented by the learned counsel for the learned counsel. No formal notice need be served, however, extra copies be served for list to the learned counsel for the petition so and so during the, within 2 days.
Well,
Expired
we furnish today itself. It's ready.
during the course of the day. Next, having considered the submission of the learned counsel for the parties and also on perusal of the
Lordship,
grounds.
I have been instructed, since I am standing on instruction, there is one more writ petition pending before this court. On the, assailing the same.
No, let me clarify. That second 10, that was cancelled because the ratio was not followed. That is totally different.
However, the order is the same.
Whatever it is.
And therefore, interim,
There's no interim
no,
in that case.
there is no interim in that case.
It's okay. In case,
Totally different
in
law.
this case, we'll first the interim. We'll decide.
Because this is with respect
Huh.
only to the press advertisement. I have been instructed to, if
That the grounds shown in the impugn order for press selection, press recruitment process appears to be factually incorrect as well as on the grounds on non-existent grounds coupled with the other similarly situated selection process in different districts have been allowed allowed to continue the selection process. In the interim, it is the impugn order so and so. That is 27, huh? 2702/2024. 2702.
Yes, 2024
2024.
to the extent.
The extent in respect of district hospital SEPA shall remain state this
Obliged.
after 2 weeks.
Obliged. Obliged.
Impugn order of termination dated 02/02/2017 is hereby set aside and quashed. However, liberty is granted to respondent authorities to proceed with the departmental proceedings strictly in accordance with the law. Writ petition allowed.
item number 9.
Right.
May I please, Your Lordship?
Yes.
Lordship, in fact, this matter, it's covered by a leading case law, Lordship. State of Jharkhand versus Jitendra Kumar Srivastava, Lordship. This is, here is a case is regarding furnishing of vigilance certificate due to which my pension has been withheld.
Okay.
Regular pension has been withheld. So Lordship is aware about the Lordship law regarding once a public servant is superannuated, Lordship. His pension cannot be stopped, Lordship, without due process of law, Lordship. Now, here in this case also, Lordship, the reason for not issuance of vigilance clearance is that one SIC case is pending against me, Lordship, which is yet to be charge sheeted, Lordship. So in that case, law is very clear, Lordship. Until and unless, Lordship, charge sheet is filed and the matter is taken cognizance and the person is convicted in a grievous offense, then only the pension can be withheld, Lordship. Otherwise, law does not permit, Lordship.
It's cases of 2012.
Lordship,
No charge
yes,
sheet.
no charge sheet, Lordship.
Why?
Lordship, in that, I
12
don't have
years,
any.
no charge sheet.
No charge sheet, Lordship. Lordship, briefly, in nutshell, Lordship, the facts of the case is, Lordship. Lordship, I was appointed as a temporary peon, Lordship, way back in 1993, Lordship, under the Department of Directorate of Social and Cultural Affairs, Lordship.
Yes.
At that point of time, Lordship, the Social and Cultural Affairs Department, now it is known as Art and Culture Department, Lordship. Nomenclature has been changed. Now, again, in the year 1992, my post was regularized accordingly, Lordship. And in the year 2012, there was allegations and complaint filed against me and some of our colleague, Lordship.
Yes.
Regarding forging of signature of the Director of Audit and Pension, Lordship. Accordingly, Naharlagan PS case number 19 of 2012 was registered against us. Now, this has been transferred to SIC, Lordship. Now, SIC is doing the investigation, Lordship. Now, this very Naharlagan PS case has been re-registered as SIC Vigilance PS case 08-2015, Lordship, under section 120B, 468, 471, 34 IPC. Accordingly, Lordship, when this matter case was registered against me, Lordship, I was arrested and accordingly I was put under suspension by order dated 10th February 2012, Lordship. Now, I was kept under suspension. In between those periods, Lordship, 4 years, I was kept under suspension. And then in between that, review was done and accordingly it was extended, Lordship. And then in the year 2016, the suspension order was revoked. And I resumed my duty and I was performing my duty as deputy, Lordship. And then I was superannuated on 30 April 2023, Lordship. Lordship will find it at
When
page
did you retire?
Lordship, yes, I have retired now. I'm retired now. Lordship, page 44 is the order, Lordship, of my superannuation. Page 44, Lordship, Annex 7. Thereafter, Lordship, accordingly, my application was forwarded to the Deputy Commissioner for providing of NOC, Lordship will find at page 45 after my superannuation, Lordship. Page 46, Lordship will find the no due certificate issued by Director Housing, Lordship. And page 47 is important, Lordship. This is no objection certificate, NOC, in fact. Serial number 1 is the petitioner here, Lordship. It clearly says that there is no adverse report of unauthorized occupation of public premises. In regard to unauthorized occupation of public premises, the NOC was issued, Lordship. Page 48, Lordship.
Yes, what is your stand? If charge sheet is not filed, what is the question of?
Lordship, whether charge sheet has been filed or not, Lordship.
Vigilance department has not yet filed the affidavit till now also.
Let them file. They are the one who has cancelled your business clearance.
But
Once you were given the no objection, I mean, clearance was given, but then it has been recalled,
it has been
cancelled.
recalled, yes.
So let the vigilance file an affidavit. That will be clarify.
My lordship,
If it is charge seated, I don't think 2012 matter.
even then, lordship will kindly appreciate lordship. Even the charge sheet is filed, lordship.
Yes.
Till date, no cognizance has been taken up.
No, that is the
In that case,
whole issue. That will be a chain reaction. First, we'll see whether charge sheet has been filed or not. We understand concern matters we should dispose of. That's why I wanted to know whether charge sheet has been
lordship,
filed or not.
what I'm trying to project is lordship. May kindly appreciate lordship. Even if the charge sheet is filed, lordship, if they
Yes.
take the instruction and they say that the charge sheet is filed, lordship. Till today, as per my instruction from my client, lordship, no summon from the court, lordship, as such. So it can be clearly inferred that no case has been taken
No, we
cognizance.
just cannot say. Tomorrow you may say that even if cognizance has been taken, I have not been convicted. Until the time it's convicted, you will again apply the principle of those.
Lordship, that is there, lordship. Before that, lordship, regarding the cognizance of the case, lordship, may kindly see, lordship. Lordship, I pray that, lordship, this matter can be disposed of, lordship.
We just wanted to know, what is your stand?
Lordship, so far, status of the criminal proceeding, lordship, is not exactly here available here on the record.
No, the cancellation is your vigilance certificate has been recalled or cancelled on the ground that there is a prima facie case
Yes.
on re-verification. Is it permissible?
Lordship.
Janki Raman case also says, apart from seal cover procedure, unless charge memo or charge sheet is filed, let's not talk about the cognizance, 1991. If it is filed,
even
not
lordship,
for, of course, not for payment of pension. Let us see the judgment which you have relied. Just see this one. Page 50. Mr. Tapin, page 50, you check this. Page 50 of writ petition. Which paragraph? Which paragraph in the
lordship,
meantime, check it.
I'll be relying on, in fact, 3 paragraphs, lordship. Paragraph 7, 13, and 15, lordship.
7, then 13.
7, 13 and 15, Lordship. Lordship, similar case, Lordship, of this coordinate bench passed by this coordinate bench, relying on this Jitendra Kumar Srivastava, same similar situated case, Lordship. Jumbo Ratan versus State of AP and others.
The paragraph 15, you read para 15. Read para 15.
It hardly needs to be emphasized that the executive instructions are not having statutory character and therefore cannot be termed as law within the meaning of appropriate Article 300A. On the basis of such circular, which is not having force of law, the appellant cannot withhold even a part of pension or gratuity, as noticed above. So far as statutory rules are concerned, there is no provision for withholding pension or gratuity in the given situations. Had there been any such provisions in these rules, the pension would have been different.
Why you are relying this?
Lordship, since vigilance clearance has been sought as per some executive orders, which I have not.
Today I have
Lordship,
delivered a judgment
Lordship.
where I have said it has the force of law. It is issued under 162. So
that in that case, Lordship, it was regarding promotions, Lordship. Now
these circulars, four circulars, which I have held to be as good as a law or having a force of law.
But Lordship, in regards,
which has been issued under in excess of power under 162, Article 162 of the Constitution of India. Those circulars includes the pension, not only the promotion. Of course, the case was with regard to promotion. But those circulars were put to challenge.
Lordship, in regards to pensions, Lordship, pension rules is very clear, Lordship.
Yes.
Under which rules, under which ground the pension can be withheld, Lordship.
No, because of my judgment delivered today, I may not agree with this. It simply says these are executive instruction. Executive instruction can have the force of law also. If it is issued in excess of power under Article 162. Unless it's supplant.
That is one aspect. Another aspect of argument may be kindly.
You show us where unless charge sheet or it is taken cognizance
I
by
had a
the court.
judgment of Madhya Pradesh, Lordship. I could that judgment I have kept it in my car, Lordship.
So you take a chance next time.
Lordship, that in that judgment,
Well,
Lordship,
I will ask
it's very clear, Lordship. It's very clear in that judgment, Lordship. I was going through that judgment just a few hours before, Lordship.
It has a persuasive value. We may not agree.
Lordship, may kindly see this judgment also, Lordship, the coordinate bench judgment, Lordship, Jambor
Okay.
Adhan's
It
judgment.
relied on this.
Lordship,
This
relied on this very judgment of Supreme Court, Lordship.
Jitendra Kumar Srivastava.
Lordship, yes. Then same similar situated fact case.
If you rely para 15, I may have a different view.
Lordship,
In view of
that is one leg of my
see,
argument, Lordship.
Maybe rightly or wrongly, I have delivered the judgment
Lordship,
today.
sum and substance, Lordship, is Lordship regarding pension rules, Lordship. So we cannot deviate from the pension rules.
Those promotions also, they said there's a rules for promotion. There's a recruitment rule from under Article 309, proviso to 309. So this instruction cannot override. I said, there's no question of overriding. It's having the force of law. It's if at all, it's supplementing, not supplanting. So I know this should be taken to appeal. Next.
Lordship,
Heard Mr. J.J. learned counsel for the petitioner and also heard Mr. Estafin learned senior government advocate for the state respondents. The respondent number, who is that? SIC?
Hold on, respondent number 2.
Respondent number 2. You are representing.
Lordship,
You find the respondent number 2, i.e. Secretary within bracket Vigilance Government of Arunachal Pradesh is directed to file affidavit in opposition.
Can be of instruction, Lordship, instead of filing affidavit. Instruction will suffice, Lordship. Whether the charge sheet has been filed.
we need to bring on records the Lordship, but the status of that criminal proceeding.
No, and then we'll say is directed to bring on records the status of the
SIC case.
SIC case number.
SIC vigilance case number 8 of 2015, Lordship.
8 of 2015. I've seen the 2012 somewhere. Page 50.
Page 50, Lordship. 8 of 2015. Lordship. It was re-registered, Lordship. Initially, it was Naharlagan PS case.
Within bracket BIG oblique PS case number 08 of 2015. What happened?
I would like Lordship, this Jitendra Srivastava's case, Lordship. It says, Lordship, it can be withhold, Lordship, but subject to the rules governing the Lordship employee. That's the Lordship. And in item number 2, Lordship has upheld the Lordship, the Lordship, OM issued by the state government, Lordship.
Obliged. All right, Lordship. Obliged.
Item number 10.
Till then, I may be protected, Lordship. I may be protected because it's yes, all are representing event.
My prayer is the board proceeding minus 11/11/2023, impugn acceptance order dated 10/1/2024, and impugn agreement dated 11/11/2024, and supply order that was issued on 11/1/2024 may be suspended.
Supply of what?
Supply of materials. They have given a supply order
Supply of what?
of several items. That is at page number 28.
28.
Yeah, okay. No, supply order. No, no, sir, it is at page number 75.
Hmm?
Page number 75.
Seventy?
75.
75. $74.
Yes, the 75 lots. Last page of my petition.
This is page 75,
Yes, sir.
running page. It's
My lord.
74, annexure 12. Is it annexure 12
Yeah, yeah.
or is it a part of the affidavit?
Yes, and it is annexure. It is annexure 10.
Okay.
You did petition number, yeah, na?
It's of 8 January.
Yes.
By now it might have completed.
Whatever Lordship has.
We'll say status quo.
Yes, Lordship, that will do. That will do.
Status quo is on today.
I have
Lordship,
some
please.
objections, ma'am.
Where?
My lord, may I have it?
Yes.
What happened, my lord?
It has been executed.
Yes, my lord. It is about to be completed, my lord. That is why, my lord.
That's why we said, I said, as on today, status quo as on today.
My lord, may I kindly appreciate
How-
few facts from it.
Percentage,
My lord, may I appreciate.
percentage of execution,
My lord.
90%.
We have supplied on 3 consecutive. There are 3 supply orders. The initial supply order has been challenged by.
That is all over.
That is all.
Second-
Apart from that, second also we have supplied and third also we have.
What remains? Once they have
Lordship,
supplied,
March
then in
is
that
over.
case, we'll say, sir, the
Lordship, it is not a case.
execution of the contract supply order shall be the outcome.
Lordship,
That will be better because they have said they have already executed. They have already supplied.
still then Lordship, bill is yet to be paid. I do not have the instruction right now if they have really supplied the items or not. But
So
then
in
Lordship.
in that case,
Lordship, in that case,
Immediately-
Lordship,
immediately-
they have done the work on their own risk, Lordship. They are well aware of the fact that this writ petition is pending. We are
That's-
challenging the very,
sir, that's why there is a reason we'll say subject to the outcome.
till then, no bill may be allowed to be paid to the contractor, the respondent.
It's a matter of
The-
7 days. Wait for 7 days. Subject to the outcome.
Lordship has said, we have challenged the first supply order. This, that was within the knowledge of the respondent and the department,
When
the
you-
authorities.
Okay,
Still then they kept on this,
Yes, when you move this writ
this
petition.
petition was moved on 14/2.
Yes.
14/2.
16-2.
Yes,
Then-
16/2. Then when there was no entry granted by this honorable court, so I filed an appeal, writ appeal. In the writ appeal, I was protected with interim order, and and by protecting me, that writ appeal was disposed of.
Yes.
Since this writ petition was pending, so it was to be listed few days thereafter. So on the date when this matter was listed again,
May I submit, my lord?
Yes, do you have the original records?
yes, my lord.
What is your submission?
Submission.
We'll pass status quo. You
My
make your
lord, yeah,
submission.
what happened, my lord? District board proceeding was held on 11/12/2023, my lord. And the board proceeding result was also declared on 11/12/2023. And during the process, my lord, entire tender process was made transparent. They were given opportunity to object, my lord. No objection was ever made, my lord.
Yes.
Now, my lord, subsequent to that, my lord, what happened? Cooperative exception was prepared, my lord. In the district headquarter level also. On first, it was on 11/12/2023, my lord, in the district level, and then on 5/1/2024 at headquarter level. Subsequently, LOI was issued on 8/1/2024, my lord. Letter of acceptance was issued on 10/1/24. Supply order was placed on 11/1/24. Performance guarantee was deposited on 12/1/24. The first demand was made on 15/1/24. Material supplied on 17/1/24. Now, every process was complete. Thereafter, on 31/1/2024, my lord, they submit a representation. After every tender process was complete. Now they submit a representation on 31/1/2024, my lord. By this time, my lord, the work, my lord, was already executed, my lord, for the month of January. And during the pendency, my lord, this for the month of February, March is also complete. Now, my lord, the petitioner has not been left out, man. He has been given two works, man, for Sali CD block and Polosan CD block. For Sali CD block has been given amounting to rupees 1,77,11,608. For Polosan, 1,41,89,286.
Is it a case that you have taken the
amount, my lord,
rate quoted by the amount quoted by the
yes, my lord, bidders, my lord.
No, yes, that of the appellant is that of respondent number 6.
No, my lord, it is not like that, my lord.
No, division bench has observed that.
That would be, my lord.
Have you seen this order?
No, my lord. The case is that, my lord, we have taken the amount quoted by both the bidders, my lord. Record is here, my lord. Record is here. Original
What
record
is the rate quoted by amount quoted by the petitioner?
amount. My lord, may please come to page 51, my lord. Of my affidavit in opposition. 1, 2, 3, 4, 5, my lord. In
Yes, 51.
yes, that is our assessment, my lord. Now, my lord, may please come to page 26 of the writ petition, my lord. Page 26, my lord. of the writ petition, my lord. My lord, yes, your lordship may see, my lord. MS Pacho Enterprises, my lord. 2 crore 13 lakhs 26,266, my lord. MS NK Enterprises, my lord. 2 lakhs 13 lakhs 27,346, my lord. No objection was made, my lord. In the board proceeding of 11 December 2023, my lord, we have stated in our para 7, my lord, page 4, my lord, they have not made any reply to that. That means they have admitted, my lord. And your lordship may kindly appreciate page 66, my lord. This is the first representation, my lord, after completion of entire tender process, my lord. Now, why we say, my lord, we have taken the rate of amount, my lord. It is in the original report, my lord.
Why, on what basis this was recorded by the division bench? Total bid value quoted by the respondent number 6.
Yes, my lord, may then in that case come to my writ
215.
petition, lordship. Take up my writ petition, lordship.
Comparative.
No, my writ petition, lordship. Yes, comparative statement, that is at page number 50.
50.
Yes.
No, this 26 clearly shows that his bid value is the amount quoted by him is lower than you.
No, lordship, that is not correct. That is why, lordship.
No, this board proceeding, page 26.
Page 26 of the
26 of writ petition.
writ petition. Yes.
Board has recommended
Yeah,
Pacho Enterprise. So
Lordship,
you are
exactly-
challenging this.
Exactly how this document has been manipulated, lordship.
Okay.
That will be seen from page number 30. Oh, sorry, 50, page number 50.
50.
50, yes. I will just page number 50. Yeah, okay. Writ petition. Look this guy. Yeah. Oh, sorry. Oh, my lord, I'm very sorry. I am taking up this. Page number. Okay.
If the observation of the division bench,
My lord.
is telling
Observation
that
of division bench, my lord, page 34 of the writ petition, my lord. Page 34, my lord. This is the, my lord, what happened, my lord? It is claimed by the petitioner, writ petitioner that the amount quoted by page 34, my lord. By the private respondent, my lord. Rate quoted by the private respondent, my lord. Quantity 24. Rate in rupees 10,000. So they say it should be 24, 2,40,000, my lord.
where it is.
Page 34, my lord.
34.
Page 34 of the writ petition, my lord. Serial number 9, my lord.
What is this?
This is the quantity is, my lord, 24. Rate in rupees 10,000. So, but the bidder, my lord, private respondent has quoted 24,000 only, my lord.
This is item wise.
Yes, my lord.
We are showing only one item, CIB.
Because they are harping on this only. Now they say we have manipulated it. My lord, I have the original. We have not manipulated any documents, my lord. It is here, my lord. It is the sign and signature of the contractor himself, my lord. They say this serial number 9 has been manipulated, my lord, by us, my lord. Original is here, my lord.
How do we find out from page 34?
Page 34, my lord. That is the original reports, my lord. They say we have manipulated this. We have manipulated this serial number 9. We have not manipulated, my lord. This is the handwriting of the contractor himself, my lord. This is not our handwriting, my lord.
This is, does it indicate the total bid value quoted by the respondent number 6?
Yes, my lord. That is why, my lord, may subsequently turn over the page, my lord, where we have taken only the total amount, my lord. The pink flag, my lord, the pink flag, my lord. Yes, my lord. Total amount quoted by the bidder, my lord. This is the financial bid of private respondents now.
Yes, as per records, it appears to be lower than you.
No, Lordship, kindly come to page number 28 of my repetition first.
28.
Yes. This is the comparative statement, Lordship. And this has been provided, furnished to me when I have applied for RTI. This is the document furnished by the
Joint Director.
yes.
No.
District Rural Development is APO T. At page number 27, Lordship will find. Furnishing of NIT the documents for supply and procurement of materials under Manrega 2023 in respect of CD block Damin. At page number 27, I'm reading page number 27. Lordship. Here are the two documents that were furnished to me. One, xerox copy of justified rate. And second is comparative statement of the firms. Page number 27. Now, let us turn to page number 28, Lordship. This is the document furnished to me when I have applied for RTI. This is the comparative statement at page number 28, Lordship. Of course, we are harping on serial number 9. Although there are so many anomalies, I can show that, Your Lordship. But serial number 9 is the CIB.
What is CIB?
This CIB is Citizens Information Board.
No. Community Information Board.
Yes,
It's a signboard, my lord.
It's like that, yes.
It is a signboard. My lord.
Community Information Board.
Yes, Information Board, my lord. This is a signboard, my lord, indicating the colony A sector or B sector.
Okay, these are all
Small things.
non-perishable goods.
Yes.
Now, Lordship.
Will status quo?
My lord.
May I submit?
Yes.
My lord, with regards to quoting of my lord, bidding amount, my lord, the documents on which the petitioner is relying, my lord, that is page number 28.
Yes.
My lord can see there is no signature of board members, my lord. The document has been prepared by APO, my lord, technical. This document was never been part of board proceeding, my lord. Subsequently, how this comparative statement has been, my lord, prepared and furnished to the petitioner by way of RTI, it's a questionable issue. Now, my lord will see the comparative statement at page number 29. No signature of board members, my lord. No signature of joint director, my lord. Only the signature of APO technical, my lord. He was not a member of the board proceeding. So how they are harping upon these documents and they are pressing this document, my lord, by subsequently procuring it through RTI, that shows their connivance, my lord, with this officer just to make out a case.
This is obtained through RTI.
Yes, my lord, but this was never been part of board proceeding. My lord can see the original documents also.
This is not a part of original record.
My lord, in that case, let me take you to item number 9. That is at page number 34. Page number 34 of my writ petition.
Yes.
Item number 9, Lordship, CIB. Now, Lordship, CIB, the quantity of the item is 24. 24 numbers of this unit was to be supplied.
10,000.
Yes, Lordship. Now, in words, it is written as rupees 10,000 only. So he has prescribed rupees 10,000 for one unit. So in that case, it ought to have been 2,40,000. But instead of 2,40,000, in the second last column of this 34, this respondent number 4, he has written 24,000 only. 10,000 into 24, it is equal to 2,40,000. And it has been clearly mentioned by the respondent number 6 that he will be supplying this item at rupees 10,000 per unit. That means if the item, the total number of items to be supplied is 24, it has to be multiplied by this 10,000. When we multiply the 24 into 10,000, the figure comes 2,40,000. So here, from here, they have started manipulation.
No, my lord, may I
Having observed these anomalies, the division bench has stayed improved orders.
Even it comes to 2 crore 40 lakhs.
No.
It's in higher inside.
Yes, if it is 2,40,000, then their bid is higher than me. The respondent number 6 bid is higher than me by rupees 24 lakhs something.
But their ground is that the total bid
that is
why quoted by the respondent number 6 is 2 crore 15 lakhs.
That is that is what, Lordship, I am indicating this particular number,
Yes.
item number. They have calculated it as 24,000 only.
Yes, why?
Instead of 2,40,000.
My lord, we have taken the amount, my lord.
Why it should be
So
lost?
why this rupees in the rate in works 10,000, quantity 24, 10,000 into 24. How much it is?
Obviously, my lord, but we have taken the
Then why?
total amount. We have taken the total amount. My lord, they have.
What
not-
does this column 1, 2, 3, 4, 5, 6, 7? Serial number 9, 7 and 8 column. Amount in rupees, amount in words. What does it indicates?
Yes,
According to him, if you have quoted 10,000 per unit, I mean per what do you call it? Per unit. Per piece.
Per piece, yes.
In
We
simple
can
language,
say-
per
yes.
piece. Then since the quantity is of 24,
Yes, my lord.
it has to be,
This amount has been quoted by, my lord, the private respondent, not by me, my lord.
but then it is quoted, but then you have taken this.
Yes,
You
my
cannot
lord.
take this.
We have taken that amount, my lord.
24,000.
24,000. Yes, my lord.
Then obviously it shows he'll be lower.
But if there is any, my lord,
Yes,
discrepancies
if
also-
you have taken
My lord.
this amount,
My lord.
if it is 24,000, obviously his bid rate quoted by the respondent 6 will be lesser than him.
Yes.
Therefore,
it is
he
taken to be
will be-
24,000. Yes.
Respondent
Even
6
then,
will
my lord,
be.
he has no right to claim.
Yes,
my lord,
ma'am.
bid, my lord. This
Huh?
is settled law, my lord. L1 does not have any right, my lord.
You are not saying he's L1.
Yes,
You are saying he's L2.
yes. Yes, yes.
You have awarded the tender, I mean, the work to the L1.
My lord.
L1 only.
Yes, my lord.
Having found respondent 6 as L1, you have awarded.
Yes, my lord.
Now he claims that I am the L1. He quoted this and you have taken a lesser amount.
No, my lord, the position.
2 lakhs you have minus yourself.
Then,
You
my
have
lord,
subtracted it and to make him L1.
my lord,
That's all.
We say, my lord, there is a delay, latest, my lord, and accusation.
No, that is
11, 12,
no, no.
2023.
That will consider.
Yes, sir. 11, 12,
But if
2023.
if the issue goes to the, I mean, root of the matter, we'll consider.
But may I?
Because of this only will stay. In
But
fact, not
may-
status quo.
No, my lord. My lord, I would like to, my lord, rely on what Tata Motors Limited.
Hmm?
Tata Motors. Para 54, my lord.
Why not
It is
consider
very
this?
specific, my lord, here. May I read?
We found it prima facie and as indicated by division bench also.
Right.
This is the reason. We'll record this. You have taken this amount as 24,000,
Yes.
whereas it should have been 2,40,000. Huh?
Yes.
Yes.
My lord, and my lord,
Heard Mr. Ding,
My lord,
learned counsel for the petitioner.
My lord, I may allow to submit more, my lord.
And Mr. You submit all this thing at the time of
No, my lord, they didn't have
only
any.
for interim prayer.
My lord, I have raised the issue of maintainability also, my lord.
We'll keep it open.
And that apart, my
We'll
lord,
keep it open.
I have another submission, my lord.
And
At-
Mr. B. Pitcher, learned dissenting counsel for
My lord, in that case, let it be the outcome of the writ petition, my lord. Otherwise, my lord, I have a serious objection.
no, this.
My lord, because they
we
cannot,
we found a serious discrepancy.
my lord, evaluation cannot be done at this stage, my lord. Whatever
We're
done,
not evaluating. We're on the pace of the record,
even if there is a arbitrariness in the
base of the-
calculation, my lord.
not arbitrariness. Aberration. If there is aberration, we may consider. It's a serious lapses. The issue is who
My
is
lord-
L1. It's not that he may be L1. It's the law is that he has no indefeasible right to claim that he should be given the contract. It's not your case. The department has said since you are the L1, because of this calculation, which he found is a serious
My lord,
discrepancy.
serious prejudice will be caused to me, my lord. I have already supplied the materials, my
Therefore, we'll say status quo.
my lord.
You have supplied. It's all right. All right. Happy.
Yes, sir.
And also, Mr. Dubey,
Dubey, my
R. Dubey,
K. Dubey.
K. Dubey, learned counsel appearing on behalf of respondent number 6. Admit the petition for final disposal. Admit this writ petition, list for hearing after on when?
First week of May, my lord.
Yes, that will do.
First week.
Yes.
First week of May 2024. On the perusal of the record, at page 34, the respondent number 6 has quoted a rate of rupees 10,000 in respect of CIB. At serial number 9. Per unit.
For numbers, it is written as number NOS.
Okay.
Numbers. As per.
Per number. List of the total numbers of CIB. Numbers are 24.
24.
List of if the rate quoted by the respondent number 6 is taken as rupees 10,000 per number, it would come to rupees 2,40,000.
Lordship, the total will be 2,15,000. 2 crore 15 lakhs 42,266.
Okay.
215.
10 into 24. It comes like that.
That is 2,40,000 for that
Okay.
particular item.
That is on that particular. 2,40,000.
40,000.
40,000. Whereas it appears that the authorities has taken it as rupees 24,000 only, which is clear on the page of the record at page 34 of the red petition. Is it a, what is comparative statement or what?
Yes, Lord, this is the bid submitted by the private respondent number
Sorry.
6.
Keep it like that.
Comparative statement is at page number 28.
Ultimately, the rate quoted by the respondent number 6 would be how much? Rupees
When
total,
when it is taken to as 2,40,000, then the rate quoted will be 2 crore 15 lakhs 42,000.
41,000.
It is 42,000.
42.
Yes.
42,816.
No, 266.
266. Just properly calculate and give it the figures.
Yes, Lord. Yes, Lord. I have Lordship calculated it, Lordship.
Whereas the bid quoted by the petitioner is
2 crore 13 lakhs 27,346.
Mr. The Learned Standing Council for the Rural Development Department submitted the original records. What is this comparative statement?
No, that is the bid submitted by the private respondent.
Bid submitted
Financial
by
bid.
bid submitted by the respondent number 6, which is shown to be rupees 2 crore 13 lakhs 26,266. Is it? Is it so?
That is the original, my lord.
Yes.
Yes, my lord.
But you have shown the totals.
Yes, my lord. We have taken the total amount,
Now we have taken this page 34.
my lord.
Because you have taken 24,000 only, not 2,40,000.
Well, that is why, my lord, we have taken the total amount from of all the items, my lord, not the rate, my lord.
Whereas the, sorry, what was the bid quoted by you?
My bid, it was 6,000 something, Lordship.
Two crore 13 lakhs, my lord.
The total amount, Lordship.
Yes.
Lordship. Then my bid, I have quoted
2 lakhs 13.
2 crore.
13 lakhs 27,000.
Yes, yes.
27 lakhs. Yes.
346. I think already it has been recorded also.
Which, considering the above, this court finds that prima facie the respondent, the petitioner is L1. Mr. Having considered in view of the above, the parties shall maintain status quo till the next date of listing of the matter. Before that. Considering the above, this court finds that there is a serious discrepancies. The serious discrepancy has cropped up in calculating the bid rates quoted by the respondent number 6, which is shown to be the L1.
Well, this maintainability part may be kept off. Because the rate itself is not
yes, the learned council, since the learned council for the respondents have raised a serious issue of maintainability.
Because the main writ petition has been withdrawn.
Present writ petition.
They have withdrawn without legal.
Without liberty.
Such an issue shall be taken up on the next date fixed. Or we'll say the issue of maintainability is is kept open. my lordship.
No issue.
So we'll take it back, the learned standing council to the learned standing council is directed to what do we say?
I will submit it to the office, my lord.
No, you
May
keep it
return.
yourself.
He may be directed to bring it again.
The learned standing council is directed to retain the original records with him till the
It's
next.
very difficult. my lord. If it is misplaced, I will be in trouble.
Take care of that. You give it back. You retain it. We have some
No.
doubt.
Much obliged.
Obliged.
Item 27.
No one appears for the petitioner on call. Mr. I. Leonard Senior, Leonard Additional Senior Government would present. List after 4 weeks.
Item number 16 and 17.
What is to be done today?
Information Commission.
Yes.
Lordship, I'm on behalf of the petitioner
Huh?
and we are yet to receive the affidavit in opposition, Lordship.
Yes.
May I please, Your Lordship, I'm appearing for respondent number 1, Your Lordship.
Hmm.
We are yet to receive our instruction, Your Lordship.
Heard MS so learned consent for the
Lordship,
petitioners.
we would like to request to kindly continue the interim order, Lordship.
Yes. MS P.
Tojam
P.
Mosang.
Sangeeta, learned council, legislative council, representing the respondent number
1, Your Lordship, only 1.
and Mr. P. Omo.
Actually, 16, I am for respondent number 2 and 3. No, sorry. 4 and 5.
4 and 5 in
2 and 3.
respondent number 2 and 3 in writ petition 577 and respondent number 4 and 5.
4 and 5 in the writ
5
petition,
in writ petition 2. Huh?
4 respondent number 4 and 5 in 577.
577 2023 and 2 and 3.
Yes,
2 and 3 in writ petition 273 23.
Your Lordship, I'm in,
Granted 3 weeks time to file affidavit in office.
Lordship, I'm in item number 16 only, Your Lordship.
It's okay. The interim order passed earlier. Shall continue.
Obliged.
Item number 21 and 22.
Understood.
My lord, as permitted in IA number 57 on the
Yes.
last date, but I have filed a amended petition. My lord, by this I am just seeking your lordship's permission to allow me to place the amended petition in the contempt petition number 5 of 2024.
No, after the filing, there's no question of acceptance. The registry will correct it and will issue notice.
My lord, in the main contempt petition. My lord, then in this case, I
In view-
not
In view of the
or
filing of, you have filed by this IA or separately you have filed amended petition?
this IA for permission to place the amended petition. Amended petition I have filed.
You have annexed this?
Yes.
Annexed, by filing this IA, the applicant has filed the amended petition as directed by this court. in
Contempt 05.
the amended petition in connected contempt case number 05 of 2024. When was that order for amended petition?
My lord, I have indicated in my paragraph 2, I have included paragraph 11 and 12 in the contempt petitions, only 2 paragraphs. That is the only changes. And the cost title. In the cost title, I have arranged.
No, you are only to file amended cost title only. Rest will take care. Not the any other paragraphs. Only amended cost title.
In paragraph 11 and 12, what actually that LS contender has acted upon, that I have given.
That is not in the way of IA. It should be additional. It should be additional. What did you say? Heard Mr. T. Patil, Learned Counsel for the petitioner, the applicant. Applicant oblique petitioner. It is submitted at the bar that the amended cost that has been filed in the connected contempt petition number 05 of 2024 or on 2024. Christopher.
In the main
which is
maybe issued.
Which is taken on record in the contempt main case, huh? In view of the filing of amended cost title by the petitioner, issue notice to the newly implemented respondent number
3.
Respondent number 3, returnable by 4 weeks. 3 weeks. Petitioners to take steps for service of notice to exercise, huh?
No, that order was passed on 9, not 8. Was
9.
9.
9/4/2020.
Item number 23.
What is this? Why this has been listed?
Your Lordship, this IA is filed for staying of the compensation.
Huh?
Staying of the compensation to be dispersed.
It was taken up for why?
Actually, we missed the interim prayer in the main petition. We missed the interim petition in the.
Where it is? Where is the IA? You have filed an IA?
Yes.
Where it is? There's no IA. You have filed today?
Yes, we have filed. We already got
It's not on record. Have you furnished the copy?
Yes, we have already furnished.
WPC.
WPC is listed, but IA is not listed.
IA is not there. In writ petition, huh? This writ petition was taken up on 1004 2024. And the notice was issued returnable but 4 weeks. Today, on the mention of the Learned Counsel by the petitioner, it has been listed wrongly.
Actually, we have filed for the IA.
According to the petitioner, a Learned Counsel petitioner, she has mentioned for listing of the IA.
Yes, for
in the writ petition. However, there is no IA brought on record. List accordingly. Writ petition. I'm sorry, it's not listed.
Item number 90.
Yeah. Oh, Alah.
My lord, in the previous hearing, the learned counsels, they have not pointed out one order of this honorable court. The order dated 1st November 2021. 2020. Hmm. First November 2021. As per this order, my lord, answer script has to be either evaluated or re-examined by the expert. After that process is completed, then only your lordship may hear the matter.
Lordship, that order, judicial order, Lordship, that was modified in the later stage, I believe, Lordship. I do not have the record, but I believe that was modified.
I don't remember any modification of this order.
The requirement of expert opinion was done about the later stage.
Let this process of this, let this process be completed.
Lordship,
The process as per below this order says expert opinion is required. My lord, I have other judgment similar to this order. Similar to this order means, say for example, in para 10 of the my lord, I'll press for compliance of this order. Order dated first.
Lordship, already were this matter being part heard, Lordship. So we have put in lots of effort to get it disposed. of course, my senior colleagues, he has cooperated all along. Now, why he's coming up with new plea, I'm not getting. Since we are on the merit itself, because this expert lordship has seen. During the time, I think there was no live streaming of the court proceeding. When this order was passed, the order referring. I would rather pray that this matter may be disposed of. We- lo- 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 गोत्र प्लेस नहीं किया था क्या एक बार हमको लग रहा है गोत्र प्लेस किया था एक बार प्लेस करा बोलते बड़ा करने से मिला हम पहले नहीं देखा we have not checked the record but that because after the passing of that judicial order lordship, if, this court has taken up this matter several times, and in those occasions, lordship, this issue was not raised in fact. We are on hearing also. Even after passing of that matter, lordship, we were.
Private respondent number 3.
My lord, we are already in 50 years of this lordship. If this order is to be lordship implemented, it will again delay the matter further lordship. Yes, Lordship. Yes, in the subsequent occasions. Yes.
Lordship, to my understanding, Lordship, this order is a interim in nature, Lordship. It can be merged with the Lordship final decisions that may be taken by this court in this matter, Lordship. It's up to this honorable court. Original, Lordship. The answer is script, Lordship. Original is not there. And I'm sorry about this order, Lordship, because I was sorry, earlier my addition was conducting this case, Lordship. Only I took up on last two occasions because she is not there.
Yes, Lordship. Not today, it's okay, Lordship. Yes, yes. My
Otherwise, Lordship, this matter can be disposed of, directing the Lordship the authority to get it Lordship, re-evaluate through the expert and then to pass the consequential Lordship benefits, Lordship. And otherwise, Lordship is away, Lordship. And Lordship is away, Lordship, run Singh and this honorable court, Lordship, will not aid the marks, Lordship, in case of favor of petitioner or Lordship, private respondent, Lordship. Because it is, we are not sitting in the appellate forum, Lordship. It is expert who has to do that, Lordship. This is a Supreme Court judgment, Lordship. Ultimately, Lordship, this honorable court, Lordship, cannot aid marks, Lordship, neither in favor of the petitioner nor in the favor of the private respondent, Lordship. That is the dictum of the honorable Supreme Court, Lordship.
But I have 1 month back, I have passed I've delivered judgment in principal seat. So what the mark can appoint?
Lordship, therefore, Lordship, I brought some judgment of the honorable Supreme Court, Lordship. So since Lordship,
Anyway,
so therefore, ultimately, what could be passed, Lordship?
considering that on the normally the order of this court, there is 01/11/2021. Not normally. The order referred to above ought to have been complied with, however, at this distant point of time, since the parties have agreed to hear the matter on merits.
My lord,
instead-
I have
instead of
objection to
the
that.
order.
I have objection to that, my lord.
Hmm.
Because unless this order is not complied with, I think this will be the good ground for appeal in the future. I want the matter should be disposed of here and it should withstand the test of the Superior Court.
My lord, in that case, if my senator colleagues is objecting, if he is insisting for implementation of this honorable court, then Lordship, I have filed, there is my additional affidavit where I have raised the issue that for 3 wrong answers, private respondent number 3 has also been awarded. So by that way, he has been given another 6 marks where he has quoted the wrong answers. So my additional affidavit is already there in the record. So this, all these issues may be directed to.
Then you suggest the expert and will appoint an
Yes,
agreeable-
all the issues raised either by the.
To the order passed by this court in this very order date lawsuit. Yeah, lawsuit is to give it lawsuit, make it effective lawsuit. Authority may be directed lawsuit to send the answer script of petitioner and the private respondent
To
to
the
a
expert.
To an expert, that is the lawsuit, a particular government university may be lawsuit.
It amounts to modification.
Obviously, lawsuit.
It's amount to modification.
Otherwise, lawsuit, how we can punish the expert lawsuit? Party asking the party to punish the expert is something lawsuit. It will interfere into the lawsuit, very fairness of the lawsuit, the process law.
I will rather submit lawsuit by sending the matter to the expert, so-called expert, it will delay the adjudication of this matter. Because we are already in our 6th year of this litigation of this particular case.
My lord, after obtaining expert opinion, it would be safer and more convenient for the court to decide the matter on the basis of the expert opinion.
Then, lordship,
why you all of you have not mentioned all these years?
Yes,
all these days?
after passing of that order
In fact,
also,
we have taken up this matter twice. This court has taken up this. This is the third time.
In between that order and today, several adjournment was taken. Sometimes he remained absent, sometimes I remain absent.
But then finally you said it should be listed for hearing, supplementary hearing. All of you.
Even yesterday also, this senior colleague, he ought to have apprised this honorable court that the hearing cannot be taken because of this order. Instead of doing that in all the earlier occasion, lordship, he has not raised that issue. When this honorable court
record that in that case, having considered
this should not be done in fact.
List the matter after 2 weeks. The please, Mr. Estafin Lani, senior government advocate, is directed to produce the original records.
Answer is script.
Answer, including answer script of the respondent, petitioner and the respondent number 3. We are not concerned about now 4.
Yes, but
3 and 4. We'll ask them to produce it.
Yes.
Then we'll decide.
Yes.
We'll, if you cannot, nominate or provide the names of expert, we'll
lordship, lordship, very clearly submitting, lordship. From my part, lordship, I will not be able to.
There's one communication law. Whether it has been brought on record or because as I submitted earlier lawsuit, G8 was conducting this case, so I was not by this lawsuit. Expert was communicated law by Deputy Commissioner Teju lawsuit. Here we propose for GK lawsuit SK Pase, coordinator vocational, and MS Anuradha Gupta Teju, and for computer theory Tenjin Choitam so Tuilang. This is a communication made to this to my office by the Deputy Commissioner.
Yes, it's available also in 2021.
It was punished. I think it's brought on records on that time because I was not conducting the case lawsuit.
There's no record in this.
Therefore, we sought for lawsuit adjournment till G8 has come back lawsuit. But since there was no adjournment, I came into.
Nobody informed this. Nobody appraised all this.
Yes, yes, that's correct.
I thought it's 2018 method.
Yes,
so it needs to be disposed of.
Lordship, the conduct of all the counsel, lordship,
blame goes to everyone.
Yes, correct.
Actually,
it is inferred that my senior colleagues,
including the court, were supposed to look into the thing also.
All along, lordship, my senior colleague, he too had taken part in this final argument.
We have directed them to produce the records,
Yes.
original records, including answer script. Then on their production, will appoint. If you agree, these people, these persons whom they have given, of course, way back in 2021, whether these persons are still there or not.
Yeah.
You confirm that also.
Close. Yep.
You just record this also. Mr. Kapil, after the dictation of the order, Mr. London Senior Counsel produced a copy of communication dated 17/1/2021, whereby the addressing to the additional senior government advocate in response in response to the letter issued by the letter dated 1/3/2021, the Deputy Commissioner has submitted two names of experts, each for general knowledge and computer theory, for re-examination and re-evaluation of answer script. The London Senior Government Advocate is to obtain instruction as to whether the names of the experts submitted by the Deputy Commissioner is still can be appointed for re-evaluation or not.
My lord, as I have submitted, lordship, this case was filed in the year 2018. And because of all these things, lordship, the adjudication of this matter is getting delayed. So may I pray that learned senior government advocate may be asked to do the needful within a prescribed period.
Yes, within
Prescribed
2
time.
weeks. 2 weeks.
Then thereafter, lordship, can we have that fixed date? After 2 weeks, let us have self date on that.
It's all wastage of time.
Yes, it's
For
all
for
wastage of
everyone.
time.
Yes, next.
Two. Second.
I will have to correct
May.
that.
Second May. Yes. Or second.
List on 02/05/20.
Oh, it will come back. Much of it.
All right.
Yes.
Yes, Your Lordship, this IA is for the staying of the compensation to be dispersed to the beneficiaries. If the stay won't be given, then the beneficiary, the petitioner will be deprived of the compensation.
Who else are appearing? Land management.
This matter was not fixed, lordship. I kept the file inside the bag.
What is to be done?
Lordship, notice may be issued. It cannot be hard today, lordship. At least. Yes.
Hard MS
Sonam Somo.
T Somo.
Sonam Somo, S Somo.
S Somo.
Yes.
ST Somo. Learned counsel for the applicant, writ petitioner. By filing this application, the applicant has sought for, has prayed for stay of the has prayed for stay of disbursement of compensation for Emily community land acquired for construction of Italian hydroelectric project in the district of Dibang Valley. Issue notice returnable by 2 weeks. Mr. D come to learned standing counsel for land management and Mr. Estapin. K Wang Mo, Estapin, K Wang Mo, learned state council accepts notice on behalf of respondent 1, 2, and 3. Yes. List of no more comment notice will be served. However, extra copies will be furnished to ensure. List after 2 weeks.
Yes.
Hmm.
Much.